Alrighty, chat. What is going on? Hope you guys are having a beautiful Wednesday. So, real quick, disclaimer: this is an 18 plus stream, 18 plus channel. If you are here under the age of 18, ensure that you have your parent or guardian's permission to be here. If you don't, I'm going to have to ask you to leave the stream. All right. That being said, and the disclaimer out of the way, we have a bunch of stuff to get through today. I've timestamped some stuff to take a look at. So what we're gonna do is first order of business. Okay, I want to point out people like this. All right, this is Jake Hilton. Obviously, you can tell, phenomenal guy with AI picture here, AI profile picture. Definitely matches up with the actual footage of himself compared to his absolute. Just look at that Chad profile face, or that profile picture, right? Just a fucking Chad. But listen to what this guy has to say, okay? And I'm only gonna play a few seconds of it because he doesn't even really deserve that. But I'm gonna show you guys who these people are so that you can avoid them.
Avoid the conspiracy theory path at all costs. You turn from that path at all costs. Because for those individuals that walk that dark road, I promise you, it will lead you to a place of such spiritual and mental darkness that you will not be able to properly discern truth.
Right. So that's all I'm going to play because I really can't stand his voice. So avoid people like this at all cost, okay? Because it says right here in his bio, he's a Christian Zyokuk, okay? And he's also a mouthpiece. He's a propaganda mouthpiece, okay? So sometimes they may not let you guys know. Sometimes they may not let you guys know who they are in the bio. So you'll have to pay attention to what they say. But sometimes it's really obvious, especially in the name as well. If they unironically have a blue and white flag in their name, you know that they're up to no good. They're propaganda pieces. So just look out for these guys. This absolute buffoon, this bozo, watch out for. Okay. All right. So let's see. I just wanted to make you guys aware of that. And there's also something to that too, right? Why is it, if this country wasn't involved, right? The blue and white country wasn't involved with, right, what happened with Charlie. Why is it that they're having their propaganda mouthpieces try to dissuade people from looking into quote unquote conspiracy theories? Why? It's really weird, right? All right. So just wanted to point that out because I thought that was really, really interesting. Really interesting. Okay, so let's see. I have both day 1 and day 2 up. So what we're going to do is we're going to take a look at these timestamps here, and we're going to talk about some of this weird stuff here, okay? So let's see. First order of business as it pertains to day 1, we have hour 39 minutes. So let's go. Let's see. All right. That's good enough.
As gunfire, I left my post, which was right there on the south end of the Hall of Flags. I proceeded to between right where the Fugal and the Hall of Flags meet. There's some outside stairs that I was starting to run down. As I was trying to get down to the bottom of the stairs, people are running up. People are laying down on the steps. I'm trying to jump over people to get to the bottom of the stairs so I can help stop an individual that's probably shooting.
What happened next?
By the time I got to the bottom of the stairs, I was informed on the radio that we had a shooter in custody. So I thought, at that moment, I was like, oh, that was kind of fast. Obviously, it was closer range probably because we had an individual in custody. Another officer came on and said we had an individual in custody. So I decided to, since the threat is gone, now I can assess for anybody that's injured and start looking for any medical needs that's needed at that moment. I started canvassing the area. As I canvassed the area, I was looking for anybody that was injured. I saw a kid on the ground that was on about the second or third tier of in the grass next to a wheelchair, and he was almost convulsing. I thought he'd maybe been shot. Talked to the dad as I was running over there. He said that he was just having a seizure, that he was fine, he was not injured. So then at that moment, I observed that there was no other injuries that I could see at that moment.
Okay. Was your attention drawn to anything else at that time?
Yeah, so after we got some people kind of cleared away a little bit, I thought I needed to start preserving the scene because we had a crime scene. And with some of my experience and training to that effect I decided now we need to contain the scene and help preserve as much evidence as we can. So I started pushing people off the grass, out of the courtyard area, because I knew that's where the crime scene was. So as we started pushing those guys out, my chief Long, that was right next to me, I looked down and saw an empty pistol holder that was sitting just on top of the grass. And at that moment, things had died down just a split second. I realized that the shot I heard was more of a rifle shot and not a pistol shot.
Okay, so I'm going to pause it there. How is it that they found an empty holster? That doesn't make any sense. I'm trying to think of possibilities of how that could have happened, and I'm not really coming up with any besides maybe it was planted there, maybe someone had drawn it, right, and had it on them just in case they needed to pull it, right, and it fell out of maybe their belt loop or excuse me, their belt and just landed somewhere. Because you can carry on UVU. You absolutely can carry. Right, so I imagine that there would be perhaps some people, well, those who work in AI, so some of those people would have carried, but to have an empty holster there is really, and I think that's something to note for sure, because he also said that he thought perhaps there was something up close because of how quickly they found a suspect, right? He just said that. And I'm pretty sure we just heard that, not just on day one of the live, but we just heard that here as well. So that's something to note too, and the fact that who's the guy who pulled down his pants and literally said that he's the one that did it, right? That's a little weird. That's also a little weird too, right? So, but the empty holster doesn't really make a lot of sense. Okay, so let's continue. He says another thing here.
And
To note.
what causes you to say that?
Just from being around firearms through all my trainings, the difference is, a handgun is more of a short bang pop sound. With a rifle, you have more of a longer, violent bang or crackle sound. It's more of a violent kind of sound. It's longer. So.
Well, we're gonna take a look here, find out what that actually sounds like. So we're gonna do 9mm versus let's do 30 sound. All right. Let's see. What the? No, I don't want a revolver, bro. Okay. All right, I'll just have to pull it up this way.
All right, quick test. We're gonna do the
Okay, so this is a 9mm unsuppressed.
Obsidian 9 full length. First, gonna go unsuppressed 3 rounds. Supersonic
a SIG?
3 rounds. Subsonic.
No,
grab
that has to be a
suppressor, do the
Glock.
same thing.
Right. That's what a 9mm sounds like. That's what a pistol sounds like. Let's do. Let's just do 30-06. Let's do the 30-06. Right? It's not longer. It's not at all. There's a boom, right? And it dissipates over a few seconds. Same thing with a pistol, okay? Same thing with a pistol. The only time you ever really hear some kind of crackle is because there's something that is suppressed, okay? Which again, I've already talked about with you guys. Um, that day being suppressed. Okay, so I'm not going to go too much into that because we already have a bunch of stuff to get through. So that is really weird. The fact that he doesn't exactly know what he's talking about there. So that's something to note. So that takes away a little bit of his credibility, which is very, very interesting. Another thing to note too, where is, because I had something up here. Where did I have it? Oh, hang on, I'm probably gonna have to, because I'm pretty sure it's something that I retweeted. So give me just a second, chat. Let's see what we have. I guess I must have accidentally closed out of it. Where'd it go? Dude, I had it up. Dude, I had that up. That's so weird. Yeah, that's weird, man. I know for a fact that I had that up. So, but anyways, we do know that the camera footage from his body cam just cut out. It just cut out, right? Um, or maybe it was. Oh, okay, okay. I just didn't read it, moron. Okay. So here's something to note here as well, okay? So when we're talking about his body camera footage of Bagley, which is the guy that they had first interviewed on day one, we're gonna watch this video from Ryan Matta, because bro's on it, man. So we're gonna watch this.
So I don't know if you guys have been paying attention to the worst show trial in the history of America. That is the Tyler Robinson preliminary hearings, right? This is where they're supposed to determine if they have an actual enough evidence to charge Tyler Robinson with a crime. So let's break this down. Maybe you guys can help explain this to me like I'm 5, okay? So when I was in high school, right, this is 2001 to 2005 time frame, right? And I believe this was 2020, or it's just 2003, 15, 16, that's when everybody started to chew and smoke cigarettes, right? So we'd sneak out at lunch break and go out and go to Smoker's Corner and come back. Well, one of my buddies didn't smoke, he chewed, right? And we'd always leave the cigarettes at Smoker's Corner. That way, if you ever got caught coming in, you didn't ever have any paraphernalia on you. And after school, you just run out to Smoker's Corner, grab your cigarettes, and then run back to the bus. Well, one of my buddies chewed, okay? So we had a can of chew, okay? He was putting this can of chew into his pocket, right? He had it in his hand, and then he went like this. He was like this after he came in. He put a chew in his mouth, and he came in, and he was putting it into his pocket, right, like this, just like that. Our school, with our school cameras, and I can't even tell you how far away, because we were on the other side of like a giant pond, like a mini little lake, if you will. Cameras on the school side. We're off school property on the other side of the lake. So we were coming out of the wood lines, and we were walking out of the wood lines. That's what he was doing, he was putting it into his pocket. So we were right on the other side of this pond, in the wood line, coming out and taking the trail on the side of the lake back into school property. The school was able to zoom in and crystal clear see the tobacco label on the can of chew to make sure that it wasn't like some beef jerky, whatever. Okay, that's what he ended up getting back at the time, was like an MIP, a minor in possession, because they were able to see that can of chew. Somebody reported us coming in. They went back and looked at the cameras, seen the cameras, went to the cameras. He had gotten rid of the chew. I don't know if it's his last dip or whatever, but for some reason he didn't have the can on him. But they could see in the camera that he was in possession of tobacco paraphernalia, and they charged him with an MIP. Now, I don't know if the charge stuck. I don't remember what happened. But those cameras were that good. And back in 2003, now when this first Tyler Robinson investigation broke, we were the ones who went in and dug in to the UVU's documentation on their own website, right, about the new security systems that they installed, the types of cameras, the year that they were installed, the updates, the cost, all of it, okay? So these cameras that they have, that they're showing Tyler Robinson, that you watching this? Because this is what everybody else is watching. Now, you could put this on a 60-inch TV, and you're not going to be able to tell who that is, what they look like, how they look. You mean to tell me that this campus must be using some type of technology, some type of camera equipment that has to be, I don't know, probably from the 1990s. We had better surveillance footage from the Columbine shooting, and we showed you guys that. If you just search Ryan Maddock, Columbine, Tyler Robinson, all of my reporting is still up on X, and it's all there. So the jury, or the judge,
of which we are not going to take a look at, because I'm pretty sure quite a bit of that is graphic.
is supposed to believe we don't have any.
And I do stream. I know I'm streaming on X as well, but I'm streaming also on Kick and YouTube, and I really don't want to violate TOS. So yeah, you guys absolutely feel free to go look at that yourself and compare the two night and day.
We clearly have a shot of the prone position. We clearly have the camera, but for some reason we just don't have the 40 seconds or the 20 seconds of Tyler Robinson laying in the prone position taking that shot. Now, why is that, you may ask? Well, you probably don't have it because the person on the roof was in a full-on sprint within 3 seconds of the shot being fired. So like we said in our previous video, unless Tyler Robinson magically did some type of Mortal Kombat kick-up flip while at the same time like putting the rifle in midair while kicking up, disassembling the rifle with a screwdriver and putting it into his backpack, and somehow magically got off the roof because, well, he didn't have that limp after he jumped off the roof, right? And they're showing us these videos. And this is such Fed slop that the only people that are pushing this narrative are Paramount Not So Tactical, Benny, your boy, Closet Johnson, and Tim Pocketpool. I don't fucking know because I don't know anybody who's buying this fucking Fed slop. But maybe you guys can fill me in down in the comments. I don't know. I'm just some dude in the fucking trailer park with a cut-off hoodie who's got about 0 fucks left in the tank. Let me know what you guys think.
He would be the rear of the two individuals in this particular video.
So right now, if you were to break this picture into quadrants, where would he be?
I would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just afternoon, about 12:15.
On what day?
On September 10th, 2025.
Okay. What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right.
And what are we looking at here? The judge is asking him because you obviously can't see it. You can't tell. You have no fucking clue who that person is, what age they are, how tall they are, what they look like. Are they fat, chubby? You might be able to make out the body type, but I guarantee you if you put that exact person on that exact roof and you put them all in a lineup after, not one person, or at the very least, not even 50% of them could actually guess and tell you exactly who that person was on that fucking roof. So you think that the defense is, the judge is supposed to be like, yeah, Tyler Robinson, that's him. Yep, 100%. Yep, got case closed. Put a needle in him, guys. This guy deserves the death sentence. That's what they fucking were trying to tell us. Remember that? They were advocating for the death sentence of Tyler Robinson Case closed because of the evidence. That's what Benny Jensen told us. And Not So Tactical Paramount told us, when you guys see the evidence is going to be overwhelming. That's why they didn't want the defense to know all the hardcore evidence that they had. Dude, there was like 50 cameras everywhere that dude walked. Why don't we have a good quality picture? If we had good quality pictures, when I went to school in 2003, it's 2026. And you mean to tell me that the newly installed cameras that just got installed a couple months ago or a couple years ago aren't sophisticated enough to zoom in and give you a clear picture?
Weird.
When the cameras, when I went to school, could zoom in and they could read the date on a penny in your hand while you were sitting in your car. That's how good they were in 2003. And you mean to tell me that the cameras today, modern technology, isn't better than what we're getting here? I'm not buying it, folks.
Yeah. I've not either, of course, right? Yeah, that's really weird. Thanks, Ryan, for sharing that with us. Because that really paints a clearer picture. That's something that I wasn't really thinking about as far as, well, no. I do remember mentioning the camera quality itself. I do remember mentioning that, right? There was better footage at 9/11. There was better footage on 9/11. You're gonna tell me that we can't even see some dude clearly take a shot on Charlie, right? From 2025. Really? No, I don't buy it, bro. I don't buy it at all. I really don't. That's just crazy to me. It's so crazy. Look, as someone who was looking at a newly built building back in 2024, right? Because I used to work private security, and watching CCTV footage, I saw better footage in those cameras, right? Which was also a very important building, right? So they needed good quality cameras, and those were significantly better than the cameras that are there. Which was what, installed a few months to maybe a couple of years ago. No, there's no way. There's absolutely no way. No. All right, so let's go back to day one here. I think this is also where he talks about the line of sight.
That's when I recognized it.
Okay. Is a rifle sound louder typically?
Yes.
Okay. Going back to when you heard this gunshot, could you tell where it came from? Sort of direction?
Yes, I knew it came from the east of me.
From the east of you.
Yeah.
Okay. So you see this realization comes to your mind. What did you do next?
At that moment when I saw the holster, the empty holster, I turned to my chief and I said, that was a rifle shot. And he said, I agree. And I looked up at that moment, right in the line of sight, I could see the Losi building had a direct line of sight. So I proceeded to go.
Yeah, so that's also something that doesn't really make so much sense to me. How is it that you look up and the first thing and the only thing that you see is the Losi building? How does that make any sense? Why not the building to its left or the right? Why not either? Because there were other bullets that was found on other buildings. Okay, there was a bullet that was found on another building, guys, mind you. Okay, how is it that this guy specifically looked at the Losi building and was like, "Yep, that's the place. Better go check that out." Doesn't make any sense. It makes no sense at all. Especially when the shot rings out to what he said, 12:23 in the afternoon, September 10th, right? And then he looks down, and to his wording, he says he could not see Charlie. He said he moved over to the left. How does he know that if he can't see anymore? It could have been that he could have fell back, right? And in a position that he could not have been seen. But from his viewpoint, he said before Charlie was shot, that he could see Charlie's right side. And when Charlie was shot, he couldn't see him anymore, so he assumed that he fell over to the left. Well, he didn't say he assumed. He said that that's when he fell over to the left because he didn't see him. Well, how does he know that at the time, right? How does he know that he fell over to his left side at the time? Because again, he could have fell over to his back, or fell over on his back, right? As ballistics go, right? When someone is shot from the front side, that momentum is going to carry them over that, just then depending on how hard they get hit, right? Well, I mean, even with, well, no, never mind. I'm not necessarily going to say that, because that's a bunch of what ifs, and I don't like to get into that, so I'm just going to leave that there. Because it could be, yeah, it could be a number of things depending on if the individual instantaneously loses their life there. They could actually just croak over. I've seen enough death to know when someone gets shot, and if they like croak immediately, they could just fold over front side. So anything could happen. So I'm going to correct myself there and say that. Speaking of corrections, I'm also going to correct myself on what I said either day 1 or day 2, possibly both days, on the disassembling and reassembling of the Mauser, the Kar 98. You can absolutely take the barrel off by just a few screws. So I'm going to correct myself there and say that. I was thinking the disassembly process, right? Because again, law enforcement mind, when you are disassembling any weapon system, right, you have to go through you have to go through a process called clearing, making sure everything is safe, right? So at that point in time, you're gonna take the bolt, rack it, okay? You're gonna clear the chamber, right? And then at that point, you're going to go forth and disassemble the weapon, okay? Anytime you handle a firearm, you always want to make sure it's safe and clear. All right? That's a part of firearm safety. So I wanted to correct myself there. You can disassemble that rifle with just a few screws, but then again, within 3 seconds, disassembling that rifle, putting it back in his jeans, that doesn't make any sense, bro. All right, so let's see. What is next here? We've got 2 hours, 43 minutes. So let's see. All right, we're going to start it there. Okay, so what's notable here is that a few things, actually. A few things. So it's going to start with his testimony on the beginning of that day, right? So I'll discuss a few things there, but a few things to talk about. So let's go and see what he has to say.
A line of questioning, and so I just want to make sure that we're just taking a look at the clock and when you feel is a good time to break, roughly in that 12:10 range.
I will aim for that, Your Honor. That shouldn't be a problem.
Okay, thank you. You may proceed.
May it please the court.
Yes.
Good afternoon, or morning still.
Morning.
Officer Bagley, my name is Kathy Nestor. I'm one of the attorneys representing Mr. Robinson today, and I do have some questions for you.
Okay.
So you mentioned that you checked in around 11 a.m. on the day of the shooting. Is that right?
Yes.
Did you know in advance there was going to be this event on campus?
I did. I signed up for an overtime shift, so yes. For
You
the special
signed-
event, I signed up for the overtime shift.
Pay attention
Got
to
it.
this.
And so did you attend any type of debrief or briefing or meeting to prepare for the security of this event?
I did not, because that morning when I got there, we had individuals on top of the Hall of Flags. So when I walked in, I just checked on, was going to get my uniform on. The chief, Long, got a text or an email or phone call stating that there's people on top of the Hall of Flags throwing stuff down to the tent Therefore, he sent the 2 officers that were on duty down to secure the area. I got dressed and then came back and then went to the Hall of Flags to secure that area.
So you never attended any kind of, I'll just use the word debrief or meeting to talk about what the officers on scene were going to do that day to keep everybody safe?
No, not that morning.
Do you know if there was such a meeting?
I don't know.
Keep that in
So when I
mind.
got there, it was starting to, people were throwing stuff down on the tent.
And do you know how many UVU officers you guys employ normally?
Employee, there was 15
And do you know how many were assigned to cover that event that day?
that were assigned to cover it. There was 6 of us that were, there was patrol 1 and then 5 others that were
Did
there
you-
with the chief.
Did you all have an idea there were going to be thousands and thousands of people there? Or was that a surprise to you?
Had an idea.
And you only had 5 officers?
6, yes.
6, I'm sorry, I'm counting you, I was
Yes.
thinking.
All right, so that's really something to note, okay? All right, again, my experience within the United States Air Force being security forces, literally in the name security forces, okay? We provided security, right? Public safety, security of important assets, law enforcement as well, right? Even infantry in some cases, right? So it's really surprising to me when I hear that is an instant red flag, okay? Because each and every single time that you come on to shift, right, especially with a big event, right, as high profile as this is, that there wasn't a briefing, that almost never happens. Actually, I know for a fact that never happens, okay? Even when I was working in private security, that never happened, right? There was always a briefing beforehand, people showing up, they're getting briefed on the day, what the weather is looking like, perhaps what happened before shift, if there was a shift prior to, right? Pretty much information on what the day is going to look like, where people are going to go, and what potentially may be causing problems that day, okay? So every single thing will be talked about. Well, perhaps not every single thing, right? But there will be a plethora of information that is given to people who are coming on a shift, especially when security is being talked about, right? And they're going to know where to go, what to do, right? And how the day is going to go. So the fact that they also had 6 individuals that day as security officers really speaks to me, because that also never happens. Thousands and thousands of people showed up to this event, as high profile as it was, and only 6 officers were there to maintain any kind of let's just say order, right? No, that doesn't make any sense. Again, from my experience, if there wasn't enough personnel, we always pulled over or pooled from other career fields, right? We called them augmentees. Specifically, when I was in Korea, and we sat in our DFPs, our defensive fighting positions, during exercises, if we didn't have the manning, we always pulled from maintenance or services, right, to fill those slots. That should have happened. And the fact that didn't happen, that indicates to me that either they were willfully underprepared, or they are so incompetent that anything could have happened. And UVU couldn't have done anything about it, right? Either they willfully done they've willfully done this, or they're that incompetent. I'll just shorten it and say that. All right. but it doesn't make sense to me. It does not make sense to me. Okay. So that's something to note. That is something to note. All right, here's something else as well. So I'm going to start this right here. Okay. So Nestor, she asks Bagley about Bagley's report, and he says this. So pretty sure he's looking at that report now. Can I? No. Okay. All right. I'll just leave that there and let it play out. So
All right,
that's
now
2 minute 50.
let me ask the question again.
2
Sorry,
hours,
you
50
just had
minutes.
the cover sheet up. Is that your report?
Yes, this is.
All right, and did you prepare that?
I did.
When did you prepare this report?
It looks like it was done the next day, either that day or the next day, because I wanted to make sure that I had it done where everything was fresh on my mind.
And do you have a copy of it in front of you?
I do, as a matter of fact.
May I just step in and just make sure that it's the same one? May I approach, Your Honor?
You may.
Hope you're good.
And this is, we got to ask this now. Did you use AI to help you prepare your report?
I did not.
Okay, good.
I don't know, bro. I don't know,
When you
man.
prepared your report, you referenced when you first heard the shot, don't you?
Yes.
And what is the time that you say that you heard the shot?
12:23.
Right.
As we said
And when
earlier.
you wrote that report, you did not state in your report the direction you heard that shot come from, did you?
No, apparently not.
And take your time and look
No, apparently not.
at the whole report and see if there's anywhere in there where you ever mentioned that it came from the east or to your right.
I don't see his direction.
Okay. And you also, I believe, in your report, you also don't state whether or not, you don't mention anything about thinking it came from the Losi building or anything like that, right?
Later on, when I recognized when I saw the empty holsters, I think I actually said that in there, where I see the empty holster, that I realized the line of sight.
Okay, so let's talk about that holster for a minute. So you heard.
Yeah, so he leaves that out of his statement, and this happened. He said the next day, or either the day of or the next day. Okay, which means that tells you that he's had time to recollect his thoughts, kind of go through the whole situation, and conveniently leaves the direction of the shot out. But here, he said as he was looking for injured people, he looked and found an empty holster, and then looked up. Right. Well, he looked at his chief, if I remember correctly. Let's just say he looked back at somebody that was working with him, and then he said that was a rifle shot. And the guy said, "Yeah, I agree." And then he looks up to the low C and says, "Yep, that's where it came from." But he doesn't add that in there in his statement. That doesn't make any sense. But this is also the same guy who, when he got to the top of the building, the camera audio from his body cam just conveniently cuts off. Weird. All right, so next, let's move on to 4 hours and 10 minutes. Nice.
In the building, and it wasn't until I went to the PD and actually saw him jump off of the building that I knew he was off the building.
Let me rephrase that, because I think I either asked it badly or you misunderstood me. So let me go back again. So from the time that the individual that you spotted on the video jumped off the roof, right? The individual that you thought was in the prone position.
Okay.
Between that and when you got on the roof, did you ever check to see if anybody else had been on the roof in that period of time?
Yeah, and I didn't see anybody.
So you
I
did
didn't
watch?
notice anybody.
You didn't, did you look on the video to see that entire, okay, that's what I'm asking. So you did not review the video to see if there was someone between you, that individual jumping off and you coming on, if anybody had been on or disturbed that scene in any way? Okay. But once you put the tape up, then we're confident from that point on the scene was preserved, right?
Yeah, so that's also something that almost never happens or never happens when it comes to security. We are, well, well, as security officers, you never ever go without checking cameras. Never. That's never a thing. Okay. And if anything happens, you are searching through sometimes hours of footage to get just a clip of maybe 10 seconds long, right? And you're zooming in, you're looking at potential things. I've done that. I've made statements on it. Within my own company that I've worked for, doing that all the time, man. That's just something that you don't. That's just something that you don't do. You don't not check cameras. You always check cameras, especially when you're not sure what's happened. You always check cameras, but him being law enforcement, he should have known this. He said so himself that he was prior law enforcement, right? So he should have already known this to go and check CCTV footage. He should have already known that. That should have been the first thing that he thought about doing, right? But no. So that's something that's also weird. Okay, well, let's move on to the 6th hour. Okay.
Examiner is a death investigation.
Now this is with Mr. Brush. Okay. This is with Mr. Brush. All right. So here, 6th hour is a bunch of hearsay on the autopsy, and Nestor actually makes a pretty valid point when it comes to the autopsy and the hearsay pretty much on this whole thing. So let's talk about that real quick.
Okay. Do you know whether Mr. Kirk was autopsied by the Utah Medical Examiner's Office?
Yes, an autopsy was conducted by the medical examiner's office.
Do you know when and by whom?
Yes, it was late into the evening of September 10th, or it may even have gone through into the morning of September 11th.
Okay. And do you know who
I'm going to
conducted that
refresh my
autopsy?
recollection because of the pronunciation, if you don't mind.
If it'll help you refresh your memory, that'd be great. Again, don't read it out loud. Look at it. Let me know when you've done that, and then we'll go from there.
Dr. Guajado, I believe is how it's pronounced.
Okay. You want to spell that last name?
Yes, Guajado.
Your Honor, if this is not personal knowledge, we object to the hearsay. If someone told him all of this, I don't believe this individual was present at the autopsy, so we object to any testimony about the autopsy or what he was told about it.
Mr. Sturgill.
Well, Judge, if I could, I'll just simply lay foundation for the report itself. And I think this is all information that's included on the report.
All right, so as it hasn't been moved into evidence just yet, I'm not making a ruling.
I appreciate
if you
that.
wish to lay more foundation, that's certainly your choice.
So you are aware that the medical examiner's office did conduct an autopsy?
I am, yes.
Okay. And did you receive a report from the medical examiner's office?
I did, yes.
Okay. Detailing the autopsy that was performed?
Yes. Prior to receiving the report, myself and Agent Davis visited with the doctor.
Okay. You visited personally with the doctor that conducted the autopsy?
That's correct.
Okay. And then subsequent to that, and did you discuss the autopsy with the doctor at that point in time when you were meeting with him personally?
Yes, Agent Davis and I had a fairly in-depth conversation, yes.
And where did that conversation take place?
At the medical examiner's office.
Okay. And do you recall the date and time that personal visit took place?
I don't recall.
Okay. Was it within?
It was soon after, within a few days of the incident.
Of the autopsy?
Yes.
Okay. And subsequent to that visit, did you receive a report from that doctor that you visited with?
We did, yes.
Okay. And that's the Dr. Guajardo that you're struggling to pronounce his name. Is that fair
Yeah, I
to say?
apologize, but yes, that's who it
Okay.
is.
And the report that was sent to you, do you recall when you received that report?
I don't recall the specific date.
Okay. Have you reviewed?
Here, chat, I'm going to pause this just real quick. I do have to use the restroom. Been holding it a little bit, so. All right. Oh, hang on. Forgot to reorient my camera. Sorry about that, guys. Appreciate you waiting on me to get back. Okay. All right, so let's get back to it. Right here is where I believe Nestor objects to the hearsay. So let's just play it.
That report?
Yes.
Have you reviewed, again, you stated earlier that this is not the first murder investigation that you've worked.
Correct.
Okay. This is, I take it, this is not the first medical examiner's report you've received.
Correct.
Okay. Do the reports typically look the same?
Yes, they're in a standard format that the medical examiner uses.
Okay. And this report that you received,
Yes.
from who you believe was the doctor you spoke to,
Yes.
that conducted the medical exam, was there anything peculiar about that particular report that stood out to you?
No, it appeared to be a standard form as used by the medical examiner when they send us reports.
Okay. On your monitor, Exhibit 11, I'm going to have displayed what's been marked State's Exhibit number 11, Judge, for identification.
Right.
And I believe there's 9 pages. So let me know when you see that on your screen.
It's on the screen.
All right. What I'd like you to do is just look at this as it scrolls down through the 9 pages and wait till we get to the very end. And if you need us to pause or stop or slow down, let us know. I want you to be able to look at all 9 pages.
Okay, maybe I have to skip forward just a little bit.
Or does it accurately depict what you received
Okay,
initially from
this
the
is
doctor?
where she stands up.
It accurately depicts it.
Judge, the state would seek to admit Exhibit 11.
Ms. Nestor.
Your Honor, this is an expert report without the expert being present, being offered by an individual who's not an expert in this field. If they're presenting him as an expert in this field based on the limited questions about his experience in seeing previous medical exam records, I'd like to voir dire him on his qualifications to opine about it. This is hearsay. It's highly technical. It should be presented only through an expert. It could never come in trial in any other way. We submit that it is hearsay. And to the extent they're going to ask this individual about any opinions about it, that would be improper. He's not qualified to do that. And furthermore, we just think that this is clearly falling under our constitutional concerns about the absence of our ability to be effective, to cross-examine, to question we can't even question the expert's experience or CV or anything that we would normally do to determine if this should even be accepted or considered by the court. And so we strenuously object to its admission and for all those reasons to its publication as well. There's some really personal things in there that should never be published that deal with Mr. Kirk's.
Yeah, his body, his condition, stuff like that. So she makes a really, really, really good point that this guy is not the expert. He's not an expert in this field. This isn't his evidence, right? So it would beg the question, why do they not have the actual expert to present the evidence there, right? So why do we have someone who's bringing up hearsay evidence as evidence when he's presenting this as evidence and he's not the actual expert who did the autopsy? Just apparently spoke with the autopsy or spoke with the medical examiner that performed the autopsy. That doesn't make any sense. So on day one, this is the best that they got, other than some doorbell camera footage, which there's something about that as well. And we are a little bit behind on time. So I'm going to try and rush through some of this. So I'm going to throw some information at you guys. Okay, so let's watch this real quick, because this is something to note as well. We're going to come back to this here.
Day 2 of the Charlie Kirk assassination trial, and an agent just went on the stand and said that he believes that Tyler Robinson met with a TP USA representative the morning of September 10th.
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red t-shirt and the shorts and shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
I'm sorry, what? You believe that Tyler Robinson went and made contact with a TPUSA representative? This is mind-blowing information, and the question is, if this is in fact Tyler Robinson, and he did make contact with somebody at TPUSA, who did he talk to and why? There are cameras all over the UVU campus, and even though UVU said that they did not have cameras on the roof before the assassination on September 10th, they certainly had cameras that were covering the courtyard area where Tyler Robinson supposedly met with the representative at TPUSA. So we need to roll that footage to see exactly who he met with. Who do you think it is? As always, let me know down below.
FBI. So yeah, that is some revolutionary news right there. That's some massive news, and that really needs to be looked into, because that brings up even more questions. Why is it that he met with a TPUSA representative or anyone that works in TPUSA? Why? If he didn't agree with Charlie, right? Didn't agree with his beliefs, why is it that he is bothering to meet with anyone or to do with that organization? Why? That doesn't make any sense. So he visits, right? And this brings us back to day one. He visits the campus a total of 4 times, according to Hull here. Visits 4 times. So let's go a little bit forward to 6 hours 34 minutes here. Let's see, can we get just a little bit closer? Okay. 6 hours 34 minutes. Here is where he says how many times Robinson visits the campus.
Yes, once we knew a vehicle that we were looking for and we had an actual image of the individual, then we were able to use that video footage to try and track that specific individual.
Okay, and I'm sorry, let me clarify. So when I said expand your search, I'm referencing the UVU surveillance video.
Yes, we were able to.
Okay. And were you able to identify in that expanded search, did you believe you located that challenger?
We did, yes.
Okay. Were you able to determine at what time or times Mr. Robinson visited the UVU campus on September 10th?
Yeah, we were able to establish that Mr. Robinson had been on campus approximately 4 times throughout the day, twice before the shooting, the time of the shooting, and then after the shooting later in the evening into the early hours of the 11th.
He mentions, I'm not sure if it was either shortly before or after, I'm pretty sure it's just after, that he visits at 0 dark 30, right? 0 dark 30. And he also mentions that someone made contact with Robinson. I believe that last point, right? Because there was some kind of security checkpoint. Yeah, there's some kind of checkpoint there, if I remember correctly. But I do remember him saying that there was a security officer that made contact with Robinson, right? And nothing of note of that. Nothing to note of that. That's interesting, right? How is it that 33 hours, they got him, right? And it's so crazy to me, um, how they have all of this footage, right? And not a single time did they ever think, oh, maybe some of these people who made contact with them should, I don't know, be put on the fucking stand. That makes no sense. It's just it's crazy to me, you know, with how locked down that place would have been. There's no way, there's absolutely no way that they wouldn't have had him even less than 33 hours, right? Or yeah, there's no way they wouldn't have had him less than 33 hours. That doesn't make any sense at all. No, but then again, nothing about this whole thing makes sense to begin with. So, all right, moving on to day 2. See, how are we for time? We gotta start to speed things up here. All right, so 51 minutes. 51 minutes here. We are gonna take a look at some of this footage because I think, did we? Oh, we will take a. Actually, tell you what. Let's take a look at this real quick because my boy James Lee, he has some really interesting information for us here.
So apparently, on the night of the shooting, Tyler Robinson was seen in a vehicle driven by a bald man and 3 other people. Take a listen.
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the
okay,
car?
we appreciate it. Appreciate it, dude.
Yes, I believe they thought that was the case.
This is by no means an allegation. I'm not insinuating anything other than here is a bald man with 3 other people. If you know, you know. So apparently,
all right, how's that? Is that a lot better? Oh, by the way, welcome in, Slick. How you doing, bud? Is that a lot better? Here, let me see if voice is great, awesome. Okay, I just want to be sure that voice is great, awesome. Harley.
First heard the shot, but are they fat shot?
Yeah, why is that? Why was I so low? That's interesting. Oh, it was hard to hear the video too. What?
on the night of the shooting, Tyler Robinson was seen in a vehicle driven by a bald man and 3 other people. Take a listen.
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
This is by no means an allegation. I'm not insinuating.
Interesting. Yeah. So, who is it that was in the car with Robinson? Those 3 men and one bald guy too. Perfect. Now, okay, cool. All right, thanks. Hey guys, listen. For those of you who are popping in, all right, if the audio does not sound right to you, please let me know, right? Because we're over an hour into this, all right, and I had no idea that my audio was really low. So if you guys see this, as soon as you hear it and it doesn't sound right to you, please let me know, okay? I'm going to be using this for videos later on, all right? And that editing takes a while, okay? So please let me know. Thank you. All right, so going back to day 2, all right? Day 2. So the official narrative is that Tyler put a rifle barrel down his pants. Literally down his pants. Okay. And he was able to walk around with that. All right. So let's see here. 51 minutes. Hall talks about him here.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same.
Thank you.
and,
Thank you, thank you, Slick.
The images
Appreciate it.
that we have.
Oh, make sure pay attention to that. Pay attention to that. Okay, pay attention to that. Here, hang on just a second. Let me see if I can pull something up here. There's something. Oh, hang on. I have to go to. This is just to prove a point here. All right, yeah. So this is to prove a point. All right, we are. No, day 2. Yeah, day 2. Okay, so let's watch this again real quick.
Let me ask you this.
So watching him.
You believe this is
we're
Mr.
watching him
Robinson returning to
step off the
campus?
I do,
stairs
yes.
there.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and
Watch
the
his
images that
legs.
we have.
Watch his legs. Oh, bent. Oh, leg bent, and then
from
he.
my viewing
It's
and
like
seeing
he
Mr. Robinson on the
forgot. It's like he forgot that he's supposed to have a rifle in his pants, so he stiffened back up again. You saw that first step he took, right? That first step he took. Let's see. Do I happen to have that? No, I don't. Okay, all right. Here. Yeah. Okay. Yeah. No. That first step that he took was stiff, and then he forgot for a second that he's supposed to have a rifle in his pants. So then he fixed it and was doing that all the way down. And then for some reason he switched his legs, and later on in the compilation. That's weird, right? Let's see, because there's also footage of him walking right here.
This parking structure.
Yes, we were able to.
Yeah, you guys see that he's stiffening his left leg, but here he's stiffening his right
This is a video
leg.
of Mr. Robinson returning back to campus
Watch.
the same way that he did previously on foot.
And this takes just a moment. And why? Well, let me.
And it doesn't even look like. Let's see. It doesn't even look as if there's anything in his jeans at all. Okay. All right. So let's go to this buffoon. This guy's an idiot, but let's just watch. Let's just watch this. Okay. So he talks about how you can actually take a rifle apart, right, and fit it in your jeans. What this guy doesn't fucking understand is how much this sticks out. Anyone ever shove a stick or rifle? Yeah, I have. I know what that looks like. Not a rifle, but a stick. I mean, just look how look how dumb this guy looks, dude. Look, he has to pull his shirt up just to get the rifle out of his shirt, right? And then what he does is, even if he takes it apart, it still sticks out. This is the dumbest. Dude, this is some of the most low IQ take that I've ever seen, bro. Look at how much it still sticks out. You're telling me you're telling me that no one would notice that. Nobody would notice that silhouetting. If anyone knows what silhouetting is, it's a term that defines something that you can see through someone's clothing, right? Silhouetting. But dude, it's so obvious that he has something underneath his shirt, right? But we see here, it doesn't even look like he has anything in there at all, right? And that's not to mention the backpacks that are somehow switched out from video clip to video clip. That's interesting, right? So that debunks the whole thing that he put a rifle in his pants. There's no way. There's no way. Again, it just doesn't look like at all there's anything in his pants. Dude, morons trying to defend FedSlop, dude. It's just crazy to me. All right, now we are fast forwarding to 2 hours and 5 minutes. All right, so 2 hours 5 minutes, and okay. So this is just what we talked about earlier. This is what James said, so you guys can see it for yourself.
Bullet casing. I know Mr. Cook's personal items to be returned to the family.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
Yeah, it does.
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble? Yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole... Sorry, just a moment. Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
So it's right there. This is what we just looked at. So absolutely take a look at that. Let's see. Oh, it seems like I skipped something. So let's go back to 2 hours 2 minutes. Sorry guys. There's so much that we have to get through, and we are running out of time, so we have to kind of rush through this.
Get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other
Okay, so here she's asking if he was involved with the investigation, with the processing of the firearms, or firearm, right? Like I said before, there was another bullet that was found on another building, right? So, and that's something that we've already talked about. And that's actually something that I did want to talk about, but I guess I might have just skimmed over that. Anyways, Hull was asked, now that we're on the topic, Hull was asked about that specific thing, that there was another round that was found on another building, right? But then he also explained that it was a unexpended cartridge, right? Or unexpended round, okay, that was cycled. Here's the thing. As someone who's been security, private security, also prior military law enforcement, you have to account for everything. And if one thing is missing, you get into a shit ton of trouble, okay? And you also have to do a statement, all right? You have to explain as to why and how this thing went missing, right? So for a round to just appear out of nowhere on another building, that's extremely troubling and very extremely weird. They also don't address the caliber of that round. Why is it that they don't address that? But, you know, I'm just going to leave that there. It's just weird. It's just very weird.
Words,
I was
boxing it, shipping it, sending it wherever it was going to go to be
analyzed? I was not, no.
Okay, thank you. Did you get notice? All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report. No, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
Would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay, so you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay.
Watch this, guys. Listen
You
up.
did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Okay. Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity.
Yeah, so what is talked about here was that she asked him, if I remember correctly, she asked him, how is it that he got this information? If hang on, maybe I'm getting mixed up here.
That today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car? Do you know when the tent and the stuff was actually removed from the scene?
I don't.
Yeah, maybe I'm getting something mixed up here. I wrote down in my notes that there's a possible info leak because of that's right. So in the autopsy, Nestor talks about how there's a recording of an investigation, right? But then he says that they didn't give any information to the examiner, right?
In this prelim that you got from...
There's the original footage.
Okay. That banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
Maybe I got the timestamp wrong.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. About the TP, you can take it down off of the screen, thank you. I want to talk now about the TP USA video that you got. That was the angle that was taken from behind Mr. Kirk while he was in this prelim that you got from...
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to, thank you. All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You
Okay, I
were
think it's right here.
not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have
Wait,
any
did you?
reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay.
That's interesting. Why is it that the medical examiner has information about the investigation that he or she wrote on the page? Because we have no idea who this medical examiner is. We've never seen him. Right? How do they have that information? And how is it that this buffoon is saying that they have no idea how they got that information? Who were they talking to that leaked that information? Because that's an information leak. That's what that is. It's a little weird. All right, so I think we're going to have to cut it. Yeah, we're going to have to cut it a little short so we can show up for the third day of the preliminary trial here. So there is one last thing, or last couple of things that I want to talk about too. On the 5th hour, 5 hours and 4 minutes, they talk about putting stuff or sending over to the FBI.
F lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
Okay, so why is it that we have a state prosecution, right? Evidence for a state prosecution where that evidence is sent over to the FBI? That doesn't make any sense. ATF, perhaps, maybe, but the FBI, no. The FBI shouldn't be involved in a state crime. No. That's weird. That's really weird. Okay. The FBI doesn't get if I remember correctly, the FBI wasn't involved in Columbine, right? Was it? Well, here, let me see. Let me fact check myself so I don't make myself look stupid. Let's see. Let's see. Okay, so the FBI was there. Interesting. Okay. All right. Okay. All right. Okay, so it looks like they were playing more of a support role in Columbine, right? Which I can see how that makes sense. But why are they sending evidence off to the FBI? They have state facilities to do that, right? That doesn't make any sense to me. Let's see. Then we have 5 hours, 3 minutes. All right.
Yeah, I would take.
So this is someone who's working in public safety and has no idea what a bolt action rifle is.
Custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent, do you know?
It was sent back to their, I guess, their equivalent of our crime lab.
Okay. Were there other are there
Why not just go to the crime lab?
other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was
Listen up.
a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was
action?
a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Got him. Right there. Look, they have, she has no idea what a bolt action rifle is, but she can tell you what a Kar 98 is. Which, excuse me, she can tell you that it was a Kar 98, that the barrel length of it, but she can't tell you how a bolt action rifle operates. Isn't that crazy? Oh, and it surprises me how someone who working in public safety has no idea what a bolt action rifle is. Or excuse me, has no idea how a bolt action rifle works. Working with firearms, there's no way. That doesn't make any sense, right? So that's something that really stood out to me. That's a red flag right there. Anyone in public safety, security, law enforcement, or otherwise, would know how a bolt action rifle works, because they would know how firearms work. There's training on this. All right. And I do believe she also works with training as well. So there's no way. There's absolutely no way. All right. So lastly, 6 hours, 31 minutes here. We're probably going to be a little bit late to the preliminary. All right. 6 hours, 31 minutes. This is where Baker talks about how there was multiple DNA found, I believe, on the rifle itself. Okay, contributor up to at least 3 contributors.
Through 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine, could there potentially be a 3rd person included? So for example, at D2, the location farthest to the left, I'm asking myself, that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a 2nd or 3rd individual. And that at FGA, I could be seeing the 22 from that 3rd person, but that 2nd person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Interesting. which even if there is just 2 people, right, that would call into question who's the second person and the third person's DNA, right? Who are these people that she is saying that there are up to 3 contributors now who have had their DNA on that rifle, right? So that's sus for sure. They need to answer that question. So that's something that really stood out to me as well. All right. Let's see. Is there anything? Okay, day 3. Okay, here we go. All right, so it doesn't look like they have started as of yet. It's already past 1 there, so they should already have started.
And I just get such a good vibe from Jen Falmuina.
Is this okay? So this is day 3. Okay, cool. All right. So, a lot of stuff that we went over, a lot of stuff that doesn't make any sense at all. Okay? Doesn't make any sense at all. So, kind of a recap, a little bit of both day 1 and day 2. But, you guys let me know what you thought. What really stood out to you, and what questions do you really have? Okay.
Good to know. Session. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grumander, Ryan McBride, Lauren Hunt, David Sturgill for the state, County Attorney Jeff Gray, and Chris Ballard are also present.
Good afternoon.
Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's present in the courtroom, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid inadvertent capture of privileged or
the
private
neck of
discussions
steel.
by recording equipment
Oh, yeah.
or by those present
yeah.
in the courtroom. And as you note, the microphones on your
Oh yeah, guys. The neck of steel. Okay, Charlie is the man of steel. There's no ifs, ands, or buts. Can stop a 30-06 round, save a number of people behind him. The man is a legend. Even in death, the man is a legend. Stopping literally stopping an actual bullet that blows through concrete. All right. What a guy. I mean, what a guy that was. Just it's crazy, man.
Is hearing.
Video recording and streaming of the proceedings.
I'm the pool still photographer.
All right. And have you both reviewed the court standing
By the way,
decorum order?
welcome in Amma.
Do you understand the requirements set forth in that order as they
Welcome
apply
in
to your
Amma
activities
and
today?
Slick. Make sure you guys are saying hello to one
Do you
another.
require additional time to review the order?
How you guys
or to
doing today? You guys
adjust
doing good?
equipment to ensure compliance?
No.
Do you anticipate any difficulties complying with the order?
No.
Thank you both for your cooperation. As we begin this afternoon, the court wishes to acknowledge the importance of safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone in the courtroom may be addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption. The court also expects that every person in attendance will be treated with the dignity and respect to which they are entitled to. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during their hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause, and with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today.
40 hours in 3 days.
That will close the presentation of the evidence on the part of the state.
Oh man, that's not a lot, man.
Thank you, Mr. Grunander. For defense.
A little bit of a break though, right?
Good afternoon, Your Honor.
Good afternoon.
Michael Berg for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner, also from the ATF.
All right, and to both parties, thank you, I appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.
Neo, welcome in, man. Everyone welcome in, Neo.
Just want to highlight one issue for the court because it may be that the court wants to do some time management.
Nice, dude.
The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions, not while court is in session, but during some other period of time, because the transcript of the video, which
thank
we
you,
prepared
Neo.
and we provided to the state, so the state could raise any concerns about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages.
I was
maybe
about to give you a dub, but never mind.
So to use court time for the court to look at the proposed redactions may
make sure
be an
you
inefficient
guys
use
are hitting that like
the
and
time. I'm not
subscribe
telling
button,
anyone
follow
the court
button.
should
I
do it.
greatly
I'm just
appreciate
saying
that,
we
guys.
may not want to do it between 9.
This channel is getting heavily suppressed right now. I can tell. I can absolutely tell it's getting suppressed. When covering this, obviously, since I'm of the stance that this is fake, this was more than likely an inside job. All of the evidence points to that. So I'm not shilling out for a certain country, and I'm not shilling out for this government. So they're absolutely suppressing this. So
However, we do
that
intend on-
engagement really helps. Sorry, the misclick. That engagement really helps with the algorithm. All right, guys. I greatly appreciate every single one of you, and I do appreciate every single one of you that are engaging and really just being there and supporting me, even if this isn't your content. So thanks so much, guys.
Time, or do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you. All right, does either party require the benefit of the record before we begin? To the state.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles really at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then, after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102b3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that's conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So, in summary, the court can, and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so, and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our
Okay, bro, that
evidence
sounds
in
good.
court.
Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there is a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay. Technology is challenging us again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming? All right, all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on. And if I could borrow somebody to do that to the witness monitor as well, so we all get them in sync. Thank you, sir. I appreciate that. And for the lectrum as well, let's just see if we can get that up because that could cause a delay. I just want to knock this out first. Yes. Where would that TV go? If that doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view, and then the media can look at that TV. Again, transparency needs to be viewable, not just there in concept. All right, yeah, let's go ahead and do that. How are the monitors looking? Nothing? All right.
Uh-oh.
I see. Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop to allow us to project? That may be the issue.
Are you not supposed to have your radios off in the courtroom too?
Let's take a look here. I appreciate the parties' patience, especially after I just said we're at the halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution.
We're working on it right now, Judge. Yes.
All right, and on the screen monitor here, it looks like something came up. All right, we'll just hope that the monitor for the witness works as well. All right, so we're ready to go? Just bring it in and go ahead and we'll get started. And how much time is needed for that? Well, let's go ahead and proceed, and then when we take a break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right, Ms. Hunt.
The state calls Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right.
Oh,
Agent,
man,
if you wouldn't
what?
mind having a seat. To your left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and we have a good record. All right. Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
Total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
No, it's been constant since then.
I want to talk about a bit about your training and experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, Officer Involved Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I work anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with a FBI Public Corruptions Task Force as well.
Was that all on-the-job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a FARO certified. It's a 3D FARO scan of crime scenes.
What's a FARO scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I'm I've been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI?
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have two case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD. Most of all the agencies within Utah County and even others outside of the county So we've worked with a lot of agencies with this case. It was a pretty large-scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about what we've. So, as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the two pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources. And
I wonder if he's going to mention the fact how many times Kash Patel was like, "We got him," on social media.
Close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio-video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
Where's Nestor?
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. Or I guess, how did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington.
SBI, so don't be looking into shit. That's what that sounds like.
Was he formally arrested at that time?
Yeah, after all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Mike, why is the FBI so involved? This doesn't make any sense.
Okay, it's there.
They shouldn't be so involved with it. It should be the
Before I
state
ask
that's
you about that,
leading
did
the
you have
case.
an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
And that may happen a couple more times as we go through exhibits because of agreements and disagreements that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview room in which Mr. Robinson was seated and waiting.
He was He was at an out-of-state event.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps.
At this specific point in time?
Oh, we would ask to admit it into evidence. We have, defense counsel and I have agreed upon, I guess, redaction of the video, and I would ask to publish it both to the courtroom
Not sure.
and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so So we're fine with all three steps as to this exhibit.
All right, does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Yo, where's Nestor at? Did she just happen to leave beforehand?
Has no audio, so we would like to.
Or is she like gone to the
admit and
bathroom
publish
or
it
some
at
kind of
this
shit?
time.
Like what's going on with Nestor? Where's she at?
Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically. Just
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days.
What is that?
I assume that we don't need to start over with that today.
thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection.
That looks
is
like my
overruled,
dress.
And this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the
It's right here.
electronic
Looks like
media
my plaid
coverage of
summer
the
dress.
proceeding.
You guys are gonna
Thank
see
you
me
for
in
that
here pretty soon.
clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with has like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's
Who are we seeing?
Let's rewind that a
That
bit.
objection is over. Appreciate that. All right, with that.
And Agent Davis, who are
All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
that's
All right, State's Exhibit 15 may be played.
Hang on a minute. Hang on a minute. We gotta.
And Agent
How could we even
Davis,
tell?
who are we seeing here?
How
That's
could
Tyler
you? How
Robinson.
could we even tell that that
in
is
white
Robinson?
tennis shoes. His cell phone was seized and taken from his person.
How could we even tell that just
but
from
that
the
was only
side
thing that was
profile?
taken from at that time.
We
After
didn't
he was
clearly see
transported
his
to
face.
Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement.
Yeah, right.
And then it's signed and submitted to the system.
They were able to
All right,
tell
I
it
wanna
was
talk a
him
bit
from the
about
back of
search
his head.
warrants. Some of the search
Case
warrants
closed,
that
guys.
were,
Case closed.
executed in this case. As part of
That's
the
all we need to see.
investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famawina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Falmina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was
I'm going to show
that
this to
family
you guys
friend?
later.
His name was Mike Mitchell.
Whenever we go on
And
break.
who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement?
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at the St. George court office, courthouse there. They met and discussed briefly. I was going to kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. It sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning
BRB
given
chat
on those forms that states that the information you're giving is true and accurate to the best of your knowledge. That any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down.
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained.
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
And how do you know that?
I reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down. Sorry, Judge, if I can just have a moment.
You may.
Keep forgetting to make sure I fix my camera, dude. I really hate this AI tracking that I have on it. It's really annoying, man. I'm gonna have to swap it out for something else. I thought AI tracking would be fun, but it's not.
I apologize, Your Honor. I misspoke. It's not 14.1, it's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, State's Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I make that decision.
I still don't see Nestor, man. Is Nestor out sick or?
If I may approach.
You may.
Did she have something that she needed to take care of? Like,
Thank you.
what's going on?
All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was it was found on the computer science building, on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile and as a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented up and fired. It still had the bullet projectile in the end and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD?
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but.
But ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs.
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did, yep, yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing.
Sorry, guys, check
Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing.
Oh,
it's
there she
not,
is.
I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it, and how we have given it in discovery to defense it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into Evidence States Exhibit 16?
Yes.
And as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right, and in regards to this exhibit, is as State's Exhibit 16, is there any portion of that recorded statement that occurred before the the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, turning to the defense, Mr. Novak.
Thank you. Thank you, Ms. Hunt. So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript. We have given the state a transcript we prepared ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 1102 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I am not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant. And there are portions of it which I think, especially to be broadcast, implicate other privacy interests. So
he just goes on and on, bro.
I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the state with a transcript, with a proposed redacted transcript. And in fact, today, we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do that without having to compare two documents. The other thing I want to say is that if the court did order ultimately that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it would probably take a couple hours at the most. So maybe maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it till we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't, until 20 minutes ago, even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because the state, because the exhibit contains significant content that is not admissible, even in a preliminary hearing. So I'm going to stop now, but I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit,
dude, just get on with
and the
it.
Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying, so let me respond to you.
He probably
before I go to
understood what
Ms.
you said
Hunt.
5
So,
minutes ago.
Going to your first point in regards to what this court's position and not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits
Appreciate the emojis.
that may come into court, and that allows pre-litigation. So I want to clarify that.
That's
the
a new
court statement,
emoji. I haven't seen
I'm
that
not
one
looking
before.
at the exhibits is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant. We could do it line by line or page by page. I know we have had hearings in
Oh,
this
God, no,
matter
we'll be here all
where the court has
day.
wanted to look at transcripts line by line, word by word. We're prepared to do that. But I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
Oh, no,
I
it's
just
fine.
want to categorize it and put it in a box. So what is the what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says.
Okay, more
is the
hearsay. You
exhibit.
could have just said that, bro. You
So
could
we
have
may
just
have a
shut the
little bit of a
fuck
cart
up for
before the
5
horse here,
goddamn minutes and just
because there
said
are two
that right off the
exhibits that
bat,
I'm
bro.
very confident are coming.
Oh, dude, I get so annoyed by long-winded
There are portions
people.
which are not relevant.
I really do.
There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today, in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Thank you.
And I heard exactly what the court said about the in limine situation, but I do want to
Can
just
we
say this,
can
and
we
I hope
kick
is
this
taken
guy
in
out of the
right
fucking
spirit.
court?
If this court had said to us, I'm returning the exhibits.
Please kick this
but
guy
if any
out.
party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that it's probably, for counsel, a suggestion about how future hearings where there are
Yo, chat, for real, this is definitely the guy that was teaching his math teacher lessons in the middle of giving lessons back in high school. I can guarantee you this is that kind of guy.
these exhibits, there are no disputes. These exhibits, there are
Just
disputes.
doesn't shut up.
These are the disputes, and we don't have to waste courtroom time.
You're
bringing the
doing that
court
right
up to
now.
speed on what those concerns are. It can all be briefed ahead of time.
Shut up.
And we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state what is in the best interest of your client. I staying clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement, and we can have a conversation later if the court wants to. It's up to the court.
Dude, where did they get this guy? Where did they get this guy from a fucking Happy Meal? Where the fuck did they get this guy, dude? Who is this dude?
Appreciate your thoughts.
Who is this guy? Oh, he finally shut up. Okay, thank God.
Yes, thank you,
Or
Judge. And
whatever God is out there.
as I tried to
Oh my God.
parse out, obviously we have procedural objections,
Shit, dude.
which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing. And then probably, I don't know, I'm assuming the media attorneys will want to weigh into that. Because
no closed
I do
hearing.
want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closure analysis on a topic by topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing. There may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video. It seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks.
But does it dox
because
people?
This is so important. So this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is we would put it, we allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure, or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of
the American people need to know
of the public's right of access.
We need to
know
know
be done only in the narrowest
what the
way
truth
possible,
is,
and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. We take that important. We recognize that its importance. We take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comment by any of the parties? All right. Mr. Novak.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument at sidebar, because the whole point is to protect my client's right to a fair trial. And by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
then we would like to have a very brief closed hearing to lodge another objection about the publication of this.
No closed hearing.
Of any portion of this exhibit, of certain portions of this exhibit beyond Your Honor's eyes. That's what I'm saying.
Thank you. All right. Right now, what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing.
Okay, redactions are fine. We can do redactions.
Perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, if this works for the court, is we will email to the court staff something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions, and Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting. I just want to bring myself up to speed, so on the next step, when I make my ruling, the court is ready to go.
Okay,
And
fair enough.
maximizing the time, because we also want to put up a monitor, so there's like 3 things we can accomplish in the space of 15
Fair
minutes.
enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, well, let's go a little bit longer, just I want to make sure everything is in place. Let's come back at 3 o'clock, and we'll proceed from there. Court is in a brief recess.
All right.
Oh my God. Oh, dude, that was so painful. Oh, it was so painful. Listening to whoever the Happy Meal lawyer was, bro. Dude, that motherfucker would not shut up, dude. He would not shut up. Dude. All right. Okay. So someone has been arguing with me over on X, because I have many different socials. I've got Instagram, YouTube, Kick. I'm in a few different places, right? And there is this person that's telling me, oh, that was we could talk about that a little bit later. But there is this person who's telling me that it's possible that a 30-06 or a firearm can shoot a weakened cartridge, whatever weakened or degraded cartridge, which are casing, whatever that means. That's not really to specify how it's degraded, but I absolutely disagree with that. I absolutely disagree with that. So what we're going to take a look at is we're going to take a look at this here, and then there's also another video that we're going to watch. So let's learn something today, shall we? Okay, let's make
How old is too old for ammo? Well, it all depends. You know, this ammo is probably 50 years old. It's still perfectly good. It's really more about how you store your ammo. If the ammo has been in a place where, well, basically where you would be comfortable, air conditioned, you know, not too humid, not too hot. Too cold is probably not a problem, but too hot is not good for ammo. 50 years is nothing for ammo. You know, now, the truth of it is, if you shoot this, the case necks right in here might split because they get old and it might not be reloadable, but it's perfectly safe to shoot it. So if you know what the history is, you know where it's been stored, pretty much you can guarantee that at least up to 50 years, and maybe more, you can shoot old ammo with no problems at all.
Okay. All right. Pay attention to that. If ammunition is stored, right, in a good environment, because environments matter, right? When it comes to metal, environment matters, right? So you have to consider the quality of the air, right? Where it's around, what you're storing the ammunition in, right? If you store ammunition and let's just say a water leak happens and you store your ammunition in a basement and your basement floods, right? You get everything situated with the basement, but you keep the ammunition where it is, it's going to degrade to a point to where if it continues, you don't take care of it, right? You don't do what you have to do to make sure that the ammunition is cleaned off, right? Oiled back up, stuff like that. Which is something that I would do when it comes to oxidation with water. That could absolutely do damage to the ammunition. And if there's anything that, well, I mean, oxidation does damage to a firearm over time anyways, right? It doesn't matter what, or metal anyways, it doesn't matter what it is, but especially left out to the elements and not taken care of, firearm or ammunition, and if it's left to degrade over a certain amount of time, then depending on that condition would mean the difference if it's going to be able to be used or not, right? Obviously, you cannot use a rusted bullet. You can't. That's not going to happen. Okay, it's absolutely not going to happen. It's not going to fire. However, could you use a round that's slightly degraded? Perhaps, but again, it depends on the condition of the round itself, right? Now, weakened, whatever that means, I don't know exactly what that means, but a weakened round, unless they're referring to maybe subsonic rounds or something like that, there's not really a potential for the round to make it out of the muzzle if the threshold, if there's not a certain foot-pound of force that forces the round out of the barrel, right? You guys have to understand that the round itself makes contact with the rifling. Okay, it doesn't. It doesn't just spin in a perfect circle, right? So say that let's just say that this right here is the bore, right? Oh, I don't even know if you guys can see that. No, you guys can't see that. Okay. So say this is the bore, right? Well, the round isn't here, and it just floats as it's coming out of the barrel. No, it makes contact with the rifling, right? That's how it gets its twist, because there's little grooves that flow along the rifling, the boring, or the bore. So, or I should say I mean, I guess you could say bore, yeah. The barrel, inside of the barrel. And that's how the round gets its twist. So anything that doesn't meet a specific foot-pound. Here, let's see. What amount of force does a 30-06 need to meet to leave the barrel? Okay. Here we go. Okay, so a 30-06 Springfield bullet does not require a specific amount of force to leave the barrel. Instead, it's propelled by extreme gas. Yes, but that force is applied because of the gas. Gas pressure, yes. Reaching up to 60,000 PSI, right? Pounds per square inch. Okay. This pressure translates to average muzzle energy of 2,700 to 3,500 foot-pounds of force when the bullet exits. Okay. That's a lot of force. That is a lot of force. So anything under that is not going to allow it to leave the barrel. Okay. So whatever weakened thing that these people are talking about, there's no way it's going to leave the barrel, because 30-06, they need a lot of force to push from the chamber out of the muzzle and downrange. Okay, there's no way that a quote unquote weakened round or degraded round, right? Again, depending on the condition, is going to be able to exert enough force for it to leave the muzzle. All right, so to kind of, I guess, debunk that whole thing. It just doesn't make any sense. We're going to watch this here. Uh-oh. All right, skip that intro because I don't want to get copyright.
Safe to shoot. Well, this is the right video for you. With that being said, let's get right into it. Welcome back to Clash Arms, guys. Kai over here, and today we're going to talk about, should you use your old ammo? Should you actually train with it or even use it for self-defense? Well, there's a yes and no answer, as always, and let's explain all of that stuff. Now, let's put this aside. So, you're hanging around, you went to your friend's house or a relative's house, or even your own maybe. You're going through some of the attic or basement and you found some old ammo and you want to train with it, some 9mm or some other calibers, and you're kind of wondering, hey man, this thing looks extremely old. Is this gonna blow up in my hand? Well, you know what, technically, no. Depends, and we're gonna go give some pointers. Like, if it's stored properly in a cool, dry, dark environment, like an ammo can right here, then you're gonna be good to go. Military actually uses ammo like from 50 years away. In fact,
That's true. Here, let me show you guys something. Here is one of my ammo cans. All right. See if I can. There we go. I've got some 5.56 rounds here. There we go. I've got some 5.56 rounds to show you. All right. You can tell that these have been fired because of the discoloration. Okay. Look at how that's discolored. You can tell that these rounds have been fired before. However, look at the condition that it's in. All right. I've had these rounds for a few years now. Okay. Still in good condition. All right. That is going to determine whether or not a round is going to be able to properly fire or properly be used. So let's see what happens when that's not the case.
in fact, we were shooting the M1 Grand here. We featured over at CF Contest. If you guys don't know what I'm talking about, go ahead and check Google CF Contest. You'll know what I'm talking about. We actually had one of those things featured over there. We used the ammo, I think the ammo can was from the 1950s. We popped that thing open. We fired every single one of them. Absolutely no problems whatsoever. However, if your ammo is stored in a very humid environment where it just rusted or corroded, then you may have some problems. It's problems such as it may not seal in the chamber, so you have some gas leakage, and that could actually be catastrophic. So,
yes.
Depends, right? Like this one, for example, right? We've got this 9mm.
That's massive corrosion.
That's been sitting somewhere for some time. This is not going to have, it may not have a proper seal in the chamber. It may give you a problem. Sometimes you'll have old ammo. You have to inspect it, right? When you grab the ammo, like I'm looking at this thing right here. This thing is extremely old. It's been out here, God knows how long. I'm looking at the projectile. It's not sunk in. It is tight. It's not wobbling. Okay, that's good. Casing, there's no corrosion, just some color change. Looking at the primer area, everything seems intact. This thing should be no problem. I should be able to shoot this thing all day long. And if you look at something like where the primer area is all corroded, different coloring, kind of protrudes out, you know, that might be bad news. And again, you also want to test out some of this ammo too. If it's visually looking terrible, don't use it, because you can actually have big time accuracy issues. It could damage your gun. It could actually blow up a lot more than the target that you're trying to fire, right? It could be, God forbid, hurt you or destroy your beautiful firearm. Here's another concern when it comes to firing your old ammo, and that is obviously that dreaded dud or squib load, or round just basically the primer gets struck, but it doesn't go off, right? These things could happen due to some corrosion, as I said, for proper storage. And that could be catastrophic. It could be extremely dangerous. We've all seen folks who are just firing their gun, like they just press trigger and the gun doesn't go off, right? And they're like, what's going on? And they just try to do an immediate action. Maybe some people unfortunately look at the muzzle, which I don't ever recommend doing that. Or just move the gun off the firing line and the gun goes off maybe 30 seconds later. This actually happens, guys, so be careful when it comes to firing old ammo. Once you press trigger and the gun goes click, just wait for a while, especially if you're shooting an old ammo. Just wait for a while or just do your immediate action right away, because it could actually have a delayed fire, and that could be, again, really bad.
Okay, so he gave pretty much two different scenarios when it comes to degraded or weakened ammo, right? Ammo that's been left out for the to the elements, or I should say, ammo that has not been stored correctly, right? Ammo that has not been taken care of. Okay, so in that case, it's either not going to fire. It could create a or I should say three different. Well, he gives two different scenarios. Okay, click with no boom, right? Which is just an audible click. There's nothing. There's just nothing there, right? And the round doesn't go off. Or two, there could be a potential catastrophic failure, which means that there could be some really bad harm done to whoever the user is. So you have to be very, very careful when you're using ammunition. But in the case that it does go off, depending on what the condition is, would determine if it's going to leave the muzzle or not, right? A lot of the times it could get stuck in the muzzle. So what I've always, what not always, but what I've brought up was that it doesn't make sense for someone who was going to do what they supposedly did, allegedly, to Charlie Kirk, that they would use bad ammunition. Doesn't make sense to me, right? And if this was Grandpa's rifle, okay, then I would assume, well, I mean, actually, I can't really assume. It's not really known as to how he got hands on ammunition to begin with, right? So for Robinson to get his hands on ammunition, right, would determine what ammunition he got, right? So maybe he got ammunition from a gun store, maybe he got it from his storage, right? But I do not believe that these were quote unquote weakened or bad rounds, because there was gunfire. There was gunfire, right? So it doesn't make sense to me that people believe that it was somehow a weakened round, a weakened 30-06 round at that, right? To still kind of prove that the bullet was lodged in his neck. No. Look, we've already talked about why a 30-06 round doesn't make sense, okay? We've already talked about that. I've talked about possible 22, a 223, maybe a subsonic 223, perhaps. And even with a subsonic 223, that would still do quite a bit of damage as well, especially within 50 yards with the trajectory that we were talking about. But a 223, I could see. I could see doing that. Not a 30-06. A 30-06 would have just about decapitated Charlie. And it doesn't matter. It doesn't matter if it's leaving the muzzle. If it's leaving the muzzle, doesn't matter what round they're using, it's going to nearly decapitate because earlier, right? Earlier we looked at how much force is needed, right? Which was 27 to 3,500 foot-pounds of force needed to leave the muzzle, okay, for 30-06, which means that velocity is going to be extremely fast. And anything that's traveling that fast is going to, and especially the size round that's a 30-06, it's going to have a pretty hard impact, okay? The reason why a lot of hunters use 30-30s, 30-06, 8 millimeters is because of the impact that these rounds make, right? There's a reason that why so many states, they make laws prohibiting 223s, because 223s don't do as much damage as 30-30s, 30-06, 8 millimeters. Okay. So in that sense, it's more of a humane to it's more humane to right in the creature a lot faster than a 223 would. So yeah, there's just no way a weekend, whatever that means, without any specifics, would make any sense. All right. So, but I wanted to show you guys this here. I just found this. So let's watch this real quick.
Standing from probably the third row in the bottom. I saw hit, I heard the shot ring out. I looked to my left, and then I looked over to my right. I saw him slump over in his chair forward. He slumped over. He had blood coming from the left side of his neck down his shirt, and he slumped over and he was carried off. Get off me! Get off me!
What was that about? Hang on.
His neck down his shirt, and he slumped over and he was carried off. Get off me!
Yeah, that doesn't make any. Wow, that's weird. That's weird. Supposedly this just came out. Yeah. This just came out. Not even 2 hours ago. Wow, that's massive, dude. Why is no one saying anything about this? Right? And why did TPUSA stop him from speaking? This makes no sense, man. This makes no sense. You know what also doesn't make any sense? Frank Turek, watch this.
Some people are saying, you said you were on FaceTime for 9 hours. I never said I was on FaceTime for 9 hours. I was FaceTiming my son and daughter-in-law when the shot rang out. I put the phone in my pocket.
Yeah. Yeah, here, I'll show you. Here, I want to take this away because this is X. So give me just a second. As we were watching the trial, I was looking at my socials, right? I was looking at my socials, and I'm glad I decided to take it away. All right. Yeah, so 8:50 p.m. today. All right. Well, uh-oh. Yeah, 8:50 p.m. today, this Katerina person posted this. All right. So it could very well be that this, was circulating long before, but this is the first time that I'm seeing this. This is the first time that I'm seeing this. And I've also mentioned before in my own analysis of the shooting myself, and this was way long ago. Okay, this was back September, October time. I also had spoken about this too. If death comes immediately after someone is hit, a lot of the times they will slump forward, right? I've seen way too much death to say that anything else happens, right? Okay, so when someone is hit and they immediately die, okay, they slump over, okay? So it doesn't really make sense to me why he would slump over to his left if he was hit directly from the front, right? But then again, if he was hit with a 30-06 round from his front side, one, there would be a bunch of overspray, right? And then again, two, he would be nearly decapitated. Okay? Now, it also really depends where he was hit, which would also be a tell sign of, it would explain, it would explain as to why he kind of seized up and then, fell over. But if he did slump over like that, then that would indicate something else as well, right? There are too many questions, and we're not getting a lot of answers. Not getting a lot of answers at all. So, I you know, I mean, you could if you could say that it was if we say an exploding mic, then we could definitely say that for sure. To make sure, okay, we could definitely say that it was an exploding mic, because of the things that we saw while we were there, you know, because of the residue that was found in the SUV that Charlie was stuffed into, right? Winter is coming, Jon Snow. Oh, yo, Kev, what's up, man? Welcome in, dude. Everyone, welcome in, Kev. How you doing, man? Here, how many people do I have? Because Streamlabs is telling me I literally only have one viewer right now, and that doesn't make any sense. That doesn't make any sense. Okay, so I have 2 watching right now. I think Kev just popped in here, so everyone say hello to Kev. And it looks like I do have Amma still watching from Kick. So it's really weird how they're telling me I only have 1 viewer. That's interesting. Anyways, so you could definitely say that. Oh, I meant to ask Kev, how are you doing, man? I know I haven't popped into your stream a little bit. I've just been so busy with my own stuff. So, but I will definitely pop into one of your streams here directly. All right, man. But anyways, so exploding mic theory, yeah, you could potentially say exploding mic because of the residue that was found in the floorboard of the SUV that they put Charlie into. Sure, we could absolutely say that. But with this information, and this is an eyewitness. This is an eyewitness that is saying that he
Forward,
slumped over.
he slumped over. He had
Yeah.
blood coming from the left side of his neck down his shirt, and he slumped over and he was carried off.
Yeah, and the fact that they're trying to shush him there is really that's really concerning to me, right? So we have, and what's also concerning is how the judge gave a gag order to everyone, right? To include Candace, who wasn't there. So that doesn't make any sense, right? But how do we explain how do we explain him getting hit and then slumping forward, right? Right back at you, bro. Hope you're having an awesome day too, man. How do you explain Charlie getting hit, slumping forward, and then doing this and doing that when you have an eyewitness that's saying that he slumped forward and they carried him off that way, right? But again, we've talked about the exploding mic. I'm not going to talk about it again. We're going in circles here. I do want to talk a little bit more about the 223 22 caliber, right? Because this would really only be this would really be the only way to explain as to him seizing up and then moving to his left. So what I have theorized, what I have come with, right? Just from all the things that I've seen, is that Charlie was hit in his seats because the official narrative is that Charlie was struck in his C2, right? And the round crashed into his C7 and lodged there. So let's say that someone used a subsonic 223. Okay, well, with the trajectory that I've shown you guys, right, from the back right side, right, up on one of the balconies, had shot, used a subsonic round, hit him in his C2, right, and then redirected, crashed into his C7 and lodged there. It could possibly happen. I doubt it, because even with a subsonic 223, I would imagine that it would still blow through someone's neck, right? Now, if we do the same thing for a 22, that's where we would probably come more into the realm of possibility, right? So, but then you would still have to explain, the wound, right, here in his neck. Okay. It doesn't, nothing about this makes any sense. But then again, if you look into the shooting itself, there's a bunch of AI that's in it. There's a bunch of, again, the chair clipping through objects. Okay. People's faces. All right. Let's see. Let me show you guys, because I didn't show this to you beforehand. And I wanted to share. I wanted to share this with you because this is really interesting. This is very interesting. Okay. And this should kind of, raise a little bit of a red flag for all of you. So let me see. I'm going to pull up. All right. So you see here, a lot of eyes are blended together here. I don't even know what this is. There's a lot of, there should be a body right here, but there's not. That's distorted. I don't know what any of this is. That looks like a head. Looks like a dented head. This, I don't even know what that is. Possibly a gargoyle of some kind. But you can see all kinds of distortion. I mean, just all kinds of distortion, right? Throughout that screenshot. That was taken from the crowd that day, and that was among the other screenshots that I had showed you before. Right, so there's no possibility that the entire audience was real. So how many people were actually there, right? And how many people did they silence in this way? You know what I'm saying? That's just that's just really, really weird to me. All right, but let's continue with Frank here, lying Frank.
Pocket, not even remembering they were there, because as soon as Charlie shot, I'm heading toward him and then running with him. I just put it in my back pocket. They heard the entire thing until we got to the hospital. When I pulled it out of my pocket, they were still there. I, talked to them, said goodbye. That's when I called Jack Hibbs to pray, and I Seth Dillon called me because he had heard what had happened. So I'm talking to him on the phone. I wasn't talking for 9 hours. Somebody online said I said I was on FaceTime for 9 hours till we got to the hotel. No, to the hospital. It was in my back pocket. It's amazing how misinformation just goes everywhere.
I know you had your phone on, and your son was hearing all of this too. So I mean, he must have been traumatized just listening to it all.
Yeah, it was my son and daughter-in-law. I mean, he's 35 years old, and I was FaceTiming them because they love Charlie. And I was just, first I was FaceTiming my wife, and then I said, let me call Spencer. And so I started FaceTiming him.
During the event?
During the event, yeah, both during the event. And then when the shot rang out, I just, as I say, started heading toward the car, and I just put the phone in my back pocket. I didn't turn it off. I just, instinctively. And by the time I got to the hotel, I pulled it out. They were still there. So they heard the whole thing.
That's weird. So, Frank, answer this for me, bro. Frank. Because I used to respect Frank. I used to think that Frank was a pretty decent guy, right? When I was Christian, I used to watch a lot of his stage performances where he was talking about a bunch of stuff. Had to adjust the light there, guys. I used to really like the guy, right? But then you see something like this. It's like, well, Frank, tell us the truth, bud. Did you have them on FaceTime? up until you got back to the hotel, right? And that's where it dropped? Or did you have them on FaceTime until you got to the hospital and then, you said goodbye there? Okay. Either way, it doesn't really make any sense, right? He's out. If you look at the video, he is actually filming, right? Or he's on FaceTime right there. Because that's his story. He was FaceTiming right there. He had his phone up, right? How is it that when Charlie allegedly got shot, that he doesn't immediately hang up? It doesn't make any sense as to why he would then put his phone in his back pocket. If he was immediately worried about Charlie, he more than likely would have just dropped his phone and went after Charlie. All right. So this bullshit of him putting his phone in his back pocket, it doesn't make any sense. And then for his son and daughter-in-law to be on FaceTime with him, even if it was to just the hospital, right, is insane to me to believe that is remotely possible. Again, they're on FaceTime, which means that they could hear him and he should be able to hear them as well, right? Assuming that it's going both ways, depending if he had an earpiece in or not. He should have been able to hear them. So for him to forget about them being on FaceTime, and he didn't hear them while they were on FaceTime, that doesn't make any sense to me at all, right? So there's a lot more to this situation that any of us, I think, really know about, right? Obviously, with all the AI stuff that I literally showed you just a few minutes ago. So, but let's go over real quick here. So the cop that they interviewed, which was the bald dude, they said that he said that he had they were asking his credibility. If you guys will remember, they were asking his credibility, and they asked him how many cases was he a part of, any homicide cases, right? And he said he was in quite a few that he had some involvement in. Keyword, some involvement. Why is it that he only had some involvement in it and we're having his say so, right, in this whole thing? That doesn't really make... Wouldn't his credentials be more trustworthy if he actually led these cases and had either complete or majority involvement in them, right? But some involvement that kind of tanks your credibility a little bit there, right? Something that I kind of wanted to point out too is that Nestor wasn't sitting with Tyler today. Why wasn't Nestor sitting with Tyler? Right? Because up until this point, Nestor was sitting with Tyler. So I don't know why that's the case. And then of course, so far today, they've just been trying to put more hearsay into, or bring more hearsay as evidence. But then again, Utah allows, trust me, bro, kind of evidence, which is pretty much the same as spectral evidence. So I am absolutely convinced that they are going to move this to trial based on some absolute bullshit. So, I mean, if they're already allowing hearsay right now, it's just weird to me. It's just weird to me. All right. I think I found some more stuff on X. Oh, there's let's see. There are attacks on Candace Owens, of course. That's nothing new. Let's see. Oh, here we go. Here we go. This is something interesting. This is something that I found as we were just watching this. So let's listen to this, guys. All right, well, hang on. Let me read the caption. Okay, so Utah SBI detective caught slipping on Tyler Robinson arrest timeline arrived in Washington, Utah sheriff at just before midnight, September 11th, and Tyler was arrested around 9 p.m. Then said he was already there when Tyler Robinson arrived. Wow. How could he be there before Tyler if Tyler got there 3 hours before him? That's a little weird, right? Well, let's hear the video.
We're close to midnight,
Oh, hang on. Sorry, guys. That was super loud.
maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
Did you mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
All the rest is okay. Interesting. Huh. Okay. That'd be really cool if they added that other clip in there. But that's very interesting. So, is it that he was there when they arrested Tyler, or did he show up at around? Because if I remember correctly, I remember him saying that he showed up around 12. I'm not gonna rewind it though. Yo, I just wanted to bring this up. Every single day that I've been streaming this, it's been storming. Isn't that weird, chat? Like every single day that I've been live streaming this preliminary, it's been storming. And it's also been, I guess it's also been giving me some intermittent issues. I just thought that was interesting. I just thought that was interesting. But yeah, definitely some things that really stood out to me, at least. Here, let me see if I can find anything else. So, wait. So someone actually did a AI enhanced image of Robinson, right? One of the images, and I saved it. There we go, right here. Right here. So this is an enhanced image here. And someone also posted a pixelated, but yeah, this is an AI enhanced image of Robinson in the stairwell. You can very clearly see they are not the same person. They're not the same person. That's probably why they were using cameras that were so grainy. Right? But you know, we got tools today so that we could absolutely clear up that image, right? And that absolutely does not look like Robinson, okay? But supposedly that is Robinson. That was walking up the stairwell. That's what they're saying this guy is, or who this guy is. Definitely not the same guy. So I would like to see them explain that. Of course, they're not going to, right? And just as Ryan Motto was saying earlier, it doesn't make sense how we were getting better camera footage literally in the early 2000s. As I was saying, we were getting better camera footage on 9/11 than what we're finding here, right? In the Charlie Kirk assassination. It doesn't make any sense. It doesn't make any sense at all. What are you guys thinking? You know, what really stands out to you? Let's go to Valhalla. Let's see what he's saying. He might be reading super chats, to be honest with you. But I want to see what Valhalla is saying.
Chrissy, I'm willing to bet you don't play pickleball, and thanks for becoming a new channel member. Laser Queen, he's thicker now. Everything
This
is
is
bigger in
Lance
Texas.
Twigs. Yeah, Lance Twigs. He has gotten bigger. You could tell by those pictures. He's eating good now, huh? Anyone confirm Tyler has an Audi belly button the size of Jupiter? I haven't seen him shirtless.
How would somebody know that?
I've not seen him shirtless.
Maybe they're in the furry community.
Yeah.
The furry community.
Oh, dude, that's right. That's right. That's what I wanted to. I forgot. I forgot to share that with you guys. Here, I've got a an image that I downloaded. So I want to share that with you guys. What? No, that's the thumbnail. What the fuck, dude? You know what I'm gonna do? Watch this, chat. That's how you solve that problem. For whatever reason, the image wouldn't send, so I literally had to screenshot it, bro. Don't worry, I got it. All right, so check this out. Look, I've been around furries. I know furries. This looks nothing like a furry. Okay, this looks nothing like a furry. Matter of fact, here, let me see if I can. I'm not gonna look it up on my computer because furries are questionable. Okay. Let's see. Ugh, dude, that's so weird. Why would someone dress up like that, dude? Hey, not to hate on furries, but damn, that's just that's definitely cringe. I wouldn't be doing that. All right. So we are going to do we are going to do a side-by-side comparison of what a furry actually looks like. All right. So So guys, check this out, okay? This is someone who actually looks. You can see they're in a suit. Okay, this is what furries do. They dress up in suits. Okay, they dress up in suits of characters that they have created. Okay, more than likely characters that they have created for themselves. They have someone literally make their suits, and they wear them. Right. This is not that. This just looks like someone that bought some kind of hoodie off of fucking Amazon and just wore it and took a picture in it. Okay. This to me looks like some Fed kind of shit. Okay. This looks like a Fed to me. All right. This does not look authentic at all. Does not look authentic at all. Okay. I just wanted to point that out because furry, not furry. Okay. Regular person, a little weird. Fed, all right. just wanted to distinguish the two.
Okay.
Mm-hmm. Interesting. I know this is taking a while, guys, but we're just waiting on them to come back for court. We have the video right there behind us, so we're just being patient. Make sure you guys hit that like while you're waiting. You guys can check out our descriptions. We have different merch and different things. If you're bored, you want to look around. Tim Hester Trent.
Yeah, if only you guys would like to look around at my merch. Right. Yeah, but I don't have a big channel, so I really wish some of the stuff that I'm talking about now would get to these guys. I really wish that was the case. Because I've been talking about a lot of things that just doesn't make any sense and just does not make that people really should be talking about. All right, people should really be talking about it. And I hate that some of these guys really aren't talking about it. But then again, when you're a small channel, it's easy to suppress a small channel. So yeah. But they're taking a while to get back. So I don't know what they're doing. I wonder if we have time to kind of go back to we pretty much touched on everything that I want to talk about before day 3 started. And I don't really think there's really a whole lot to say on, or a whole lot more to say on what we've already talked about. Right. So let me see if there's anything on X that we could really see. Oh, wait, guys. Hang on a minute. So Erica Kirk actually made a new appearance. She made an appearance today. You guys may not have seen that. We're gonna show you guys here. She made an appearance as well today, so we're gonna go ahead and check that out here.
Fuck God, it's Eric.
Oh. Wow. Look at that. Look at that. Oh, dude. Wow. I mean, for Erica Kirk to show up on day 2, again, that shows some courage. Really shows some courage. So make sure you guys are showing some love to Erica Kirk. Really showing up with the family. Definitely didn't show up with Don Jr. That didn't happen. No, but she came in super serious face, and very, very, very just look at that. I mean, just bro, absolutely. You got to love this woman, man. You really have to love this woman. She's such an amazing person. Definitely did not profit off of her husband's death. Not at all. Not at all. Dude, some of these memes are crazy, man. I don't even know if I can share some of them. Oh, dude, some of these memes are fucking crazy, dude. That's funny as hell, though. All right, is there anything else that we might be able to see? Uh-oh. Oh, dude, that's crazy, man. That's funny. Hey, yo, hey, look, guys, AI is crazy, man. I want to show you guys. Dude. Here, hang on. I'm gonna show this. I'm gonna show this to you guys. This is. Oh man, this is crazy. Oh wait, why? No, no, dude. Why can I not? Oh wait. I can screenshot it though. So let's do that. I'm gonna screenshot it, guys. Give me a second. All right. So it looks like someone cracked the case, man. Looks like someone found the shooter of Charlie. And uh there's some groundbreaking news here. Turns out that that AI enhancement that we looked at beforehand was a little bit off. So that's that's I mean, I'm kind of left speechless. I'm left speechless, chat. I mean, it's just crazy at how, people were able to find this out. I mean, grainy footage like that, it's hard to work with, but actually making a clear image, that's hard to do. Props go to our detectives. Props go to our detectives, man. Doing some good work. Doing some good work. All right, that's interesting. I'm not seeing anything else. So, oh wait, here. Oh, well, this is interesting. Well, let's take a look at this. There are different hats in these two different videos. Oh, wow, yeah.
In the presence of counsel and all parties, I appreciate your patience. Sometimes it takes time to save time, and so that was the intent of this court in addressing what is before this court as it relates to State's Exhibit 16. Counsel, this time I've taken time to look at the video anew, also reviewing what Mr. Novak submitted, the redactions requested, and reviewing all parts of it in great detail. All right, I want to address the objections before me, and starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride, and the court agrees, it is hearsay. At the same time, I'm only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance as it relates to State's Exhibit 16. And I agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to like scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding. But there are portions of the transcript, State's Exhibit 16, which relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout this hearing. And after this hearing, my intent is to review everything again, to be thorough. This is not a case where I'm going to be shooting from the hip in making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript as it relates to State Exhibit 16 may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. Therefore, as it relates to relevance, that ruling is reserved. Now, turning to the other objection, which is Rule 403, prejudice. As I am acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video, so both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning until that page 19, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Your Honor, would you state those times again that you are ordering not to be published? I've got 3255 to 3548.
Right. Those are the two timestamps for that. And I hope that's helpful as both parties are trying to review on the transcript and State's Exhibit 16.
And that's from 3255 to 3548.
Right.
Okay, thank you.
is not publishable in the courtroom or on to be broadcast. Finally, I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Yes, Your Honor. And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because
Sure.
I do think a closed hearing is appropriate. Setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay? Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay? I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding. And there are reporters in this courtroom who will go outside and speak on what we used to call television. That opinion was from the 60s. Now we have other forms of technology, but I'm just going to use what the Supreme Court says because it's the Supreme Court. So we are very concerned that the publication beyond this court's eyes of what the state will call confessions at trial violates Mr. Robinson's due process rights right here and now today. And I know that we said that before in the litigation, but now we're exhibit specific. If I haven't been clear about the argument, I want to make sure I'm clear about it because the court's decision to
allow this video to be televised and the other two exhibits to be shown to the camera in the back of the courtroom is exactly what the Supreme Court says violates the 14th Amendment.
So, and I appreciate that clarity, and perhaps, and again, if you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is being excluded, or is it in the
It is
court?
not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think, and the note that is referenced in Mr. Twiggs 1102.
All right, and let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client, and so I want to give it its due time. The text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months ago in their entirety.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported, in part, the charges that the state has filed. We did not put the entirety of them in. And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a motion, but Mr. Novak, I'm not sure if that's ringing any bells.
I'm aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that, certainly not the court, and I'm confident that the state's counsel would never intend to do that, but that would be the consequence of further televising what the state refers to as, previously referred to as confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging that they are statements of a party.
My cat is sitting right by my feet.
We have not filed anything.
Be careful where I
in this
step.
case that publicizes the text messages, the Discord chat, the note which Ms. Hunt is mentioning, and now that Ms. Hunt has said that yes, we want this note to be presented into evidence, and the court knows what this note is because the court's now watched the video. That's another piece of the same problem. So this is all simplified by the court being extra cautious about Mr. Robinson's constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right, I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond, because I understand what Mr. Novak's saying, and there may be a 403 issue as well.
Do not
as it relates to
close
this,
the
and I'm
court.
not gonna
God,
pretend
do
to
not
read your
close the
mind,
court.
But
just use redactions, bro.
because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitors such that cameras can capture them and
Well, I mean, that's still sus,
pause
though.
or get the
Why not just
actual
show the transcripts?
exhibits, substances of the exhibits. I believe that was the media's position, if I remember correctly, is that they want everything
Anyone could say
audio
anything.
and visually displayed, but the
And they could
state's position is just we just want the
not
audio
include
played.
the video.
Right, but what's so I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
All right, so help me understand, what's the difference if the audio's played or the video's played on what the court is identifying is, well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that is different than the court simply reviewing it in its own privacy. I don't want to misstate your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call a distinction without a difference. It doesn't matter whether it's audio or video, and it doesn't matter whether it's on a television or on the internet or on the radio.
It does.
It's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twig's video. And when the court mentioned 403, yes, I think the court did accurately read my mind, which is fine with me, but it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates to
that was like the most brief thing he said.
publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within State's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then in the future move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with the audio. But hearing the tone, the context, all of that, that's why the state chose to do, we could have done a written 1102 statement from Mr. Twiggs. We chose to do, as is allowed by 1102, we chose to do a recording because that's how the state is choosing to present this evidence. We believe that the appearance or the tone, the context, hearing Mr. Twiggs actually talk and talk through these exhibits, talk through his experience is a meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
I learned a long time ago that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations. Because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963. Sure. Citation to state standards for what is or is not a public document are not the issue. There's a constitutional issue here. And I think that the court has already heard from me at least 3 times about what we think the court should do here. It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to voir dire on yet another issue, which is whether
a jury trial,
potential
probably.
Jurors
I
were
would bet
exposed
on
to
it.
media.
Actually, I would absolutely bet on it.
Replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule, you can't televise what a prosecutor calls a confession before trial. Thank you.
All right, thank you. I appreciate both parties advocating and arguing. It's helpful for the court.
Yeah, this is absolutely going to move to trial. It has to. It has to. The FBI has been pushing for this. Government has been pushing for this for a very long time.
All right, so in
this is going to move the trial.
Taking in consideration the argument, which again, I appreciate the parties articulating, the further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8, and sorry, I'm just trying to. Sorry, starting on page 7, right after, is that at 8? Well, let's start. Starting on page 6. Now, let me go back here. Starting on page 6, after 6 minutes and 56 seconds. going to 20 minutes and 27 seconds. For reasons such as 403, under Rule 403. And again, this is simply for publication. This is not taking out what the court will consider. The court is considering the entirety of State's Exhibit 16, but the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish the court's duty as a magistrate under the probable cause determination. All right.
Can you state those times again, Your Honor?
6:56 until
20 something.
right, the line before 2027. Or 2027, just so until 2027. Is that? And then and then what the court indicated previously from
Guys, I know this is boring. I mean, I appreciate you guys hanging in there. All right, I know this is not super exciting, but
And I apologize, Judge, just to clarify.
it's super awesome that you guys are hanging in there.
These timestamps that you just gave, the 3255 to 3548 and 656 to 2027, those are just not being published, but they have been admitted for Your Honor's consideration.
Right, so kind of going through my three-step process. Exhibit 16, it's an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this case. So
how many times does he have to say this?
This is only what will be published in the courtroom and on and captured by the video. Is the differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own determinations in regards to relevance, everything that Mr. Everything that Mr. Novak noted, I'm taking that in consideration and making those determinations, which the court will do again, because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where, as it relates to publication.
Yes, thank you.
All right, to the media.
Your Honor, I know how much time the court's already dedicated to considering this, and I appreciate the additional time being afforded the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration that the court is entering into when trying to make the determination that it is going to make at the conclusion of this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta, on page 238 to 239.
Sorry, guys.
Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper means and will promote conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. The second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I believe, I understand from the arguments being made today, that many of these references are to text messages. Again, the public doesn't yet have access to that. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurks in there, something else is being kept from them that isn't. And so not only does it run counter to the idea that, of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I had, Your Honor.
Thank you. And, all right, counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen here. And we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue my final ruling to clarify what's been stated, just so it's clear to all parties? Mr. Novak, and your mic's muted.
Yes, we just want to say that we totally respect Ms. Kirk's position in this situation, as well stated by her counsel. Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due respect to the Kirk family, and with all due respect to the media, and with all due respect to the public, the number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Redu,
Rideau, yes.
Rideau. My French is bad.
Mine too.
That constructed a rule that publicizing a confession runs afoul of the 14th Amendment, but that didn't appear to be the holding. It was, the opinion talked about coerced confessions being put out to the public. Could you cite two Estes that supports?
The portion that the court is looking at is exactly what I would read to the court. It says, we constructed a rule. Now, I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was a case where there were multiple opinions. And we all understand how complicated it is to figure out what comes out of a Supreme Court opinion when there are multiple concurring and dissenting opinions. But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice analysis, without even looking at what happened in the trial vis-a-vis that earlier televised analysis. So yes, we could go down what lawyers like to do, we could go down the rabbit hole of what were all the different opinions in Rideau and why is Estes citing to a dissenting justice. But what Estes said is we constructed a rule. It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment. The Estes opinion was written by Justice Clark. There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr. Justice Goldberg, and then there were dissents by Justices Stewart, Black, Brennan, and White. So we could spend some time deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rideau versus Louisiana. It's a 5-4 opinion. And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rideau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to (20 minutes and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 32:55 until 35:48. Does that comport with what I previously said?
Yes.
All right. And then from 35:48 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes under my analysis under 403, going to the last part, needlessly presenting cumulative evidence. And based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act. But I'm trying to act in the interest of justice in making this balancing act and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it, or do you wish to go a different route?
I think just to make sure that we are completely in line with the court's ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
And if you wouldn't mind, when you have that final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state, simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
As to this exhibit, no.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
If you have just a moment.
Of course. And I know the state's engaged, but if someone could send a copy of that to the court after it's been reviewed by counsel so the court can review it to double check that it comports with what I said, to make sure that it reflects what I was intending to reflect. That way we can save time as well. Thank you.
Why is today a half day? I don't understand.
Judge, it's the state's position that we close for today, come back once those edits have been made. We can start tomorrow with that and proceed from there.
All right. Any opposition from defense?
No, Your Honor. I do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis. I'm sorry, Agent Davis. Agent Davis, as to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just making the court aware of that. It's a much simpler exercise. It's not nearly as complicated. I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinson. So it's according to Mr. Twiggs, according to the text messages, according to the Discord, and the note. All of that is part of the Estes issue. I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it, but I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to the televising of statements that the prosecution will call confessions. So maybe that's something.
It was a different prong that I was addressing.
Good, okay.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made public.
For evidentiary purposes as opposed to for publication purposes.
Right.
Understood.
Right.
But if the court wants to recess, we have no problem with that.
And so just going to your point, and again, trying to maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward? Because I want to look at in detail what you're citing to. It's difficult on the fly to jump into Estes and go to a portion, and I want to give your argument full consideration. It's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time so that at 9 a.m. the court has already had an opportunity to understand what's coming, we're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank
No
you,
problem.
Mr. Novak. And if you wouldn't mind, obviously, sending a copy to the state as well.
Oh, of
so
course,
it's not
of course.
Ex parte. All right.
So, is the court referring to a formal filing?
No, just if you
A bench
want
memo.
a bench memo, and that all sides can have a take a look at, just to prepare. Again, in light of efficiency and trying to maximize our time and give as much weight and time to addressing these issues fully, as opposed to trying to hit them at the moment and doing a deep dive when it's a little bit more difficult. So.
Happy to do so.
If you'd like to, I would entertain that to the state. If you want to confer and talk to see where you are and want to do the same, certainly you are entitled to do so as well.
I think we plan on doing that. Thank you, Judge.
All right. All right. Is there anything else for this afternoon?
Not from the state.
All right. To defense.
No, thank you very much for your time, Your Honor.
All right. Court will be in recess until 9 o'clock tomorrow morning.
Oh, okay. Well, that is day 3. Day 3 is super short. Let's see. I think I saw some stuff on Twitter to kind of take a look at here. So I'm gonna go ahead and swoosh this over here. I was looking for any updates that I could find, and so there's actually a couple here. We've got 3 things to look at actually. So what I'll do is we have one from Ryan Mata to watch. Brings up kind of a good point. Then there's something about drones that was flying around that day supposedly, and then I think the last one that we're gonna watch is the leading agent not knowing that something was done to the scene. Okay. So what I'm going to do is I'm going to just close out of that, bring this up. So we'll see this lastly. But I want to see what Ryan has to say here. First of all, let's go to this video.
Trial. Well, let me let my homie. So, just in case you were wondering why Trump decided to start carpet bombing Iran yesterday, it was most likely because of the screwdriver saga. So, if you haven't heard the screwdriver saga in the Tyler Robinson trial, well, let me let my homie Sam Parker break this down for you, just in case you missed it. Check this out. So please make sure you swing over there and follow at Base Sam Parker. The dude is based and he's a legend. And he goes, on September 11th, CNN originally reported that the screwdriver was found near the rifle. On September 15th, Kash Patel went on national TV and changed the story, saying it was found on the roof and that it had Tyler Robinson's DNA on it, thus linking him to the alleged crime scene. On September 16th, the indictment of Tyler Robinson omits any mention of that alleged critical piece of evidence. In fact, neither the charging document nor the affidavit of probable cause mention the screwdriver. The only piece of evidence that could even allegedly connect Tyler to the crime scene was left out of all documents. Now, yesterday, we find out that the officer Bragley took 21 minutes to get over the Low C Center's roof and that his body cam died literally as he got there and captured no footage of anything on the roof. Another person with a badge was with him on the rooftop, but he did not know that person and never got a name. No police chatter of the original roof.
All right, so here's something as well. This is very important when it comes to anything security, law enforcement. You have what is called pertinent information. Anyone that you make contact with any incident, you must, and I do mean you must, record names, phone numbers, potentially emails. You want to have identifiable information so that if there should be a point in time where they need to make contact, then they can do so with that specific individual that you made contact with. Not having that information is a really big problem for any case that really needs that information. So if you are here, right, and you're seeing things as it pertains to September 10th, and you are one of the first people that gets up to the building, and then you find this guy, right, who supposedly is helping you out, but you don't get any pertinent information, that sounds to me like either incompetence or willfully leaving out information. Okay, because that is almost never heard of when it comes to security or law enforcement. Trust me, again, I'm prior military law enforcement. I know. I know what happens when you make contact with anyone, okay? You have to get information, name, phone number, email, whatever, to be able to contact those people should they need information, okay? Pertinent information, it's needed.
Searches mentions anything of a screwdriver. So what are we supposed to make of this, guys? So now I want to explain why I think we should subpoena or we should FOIA request, and Tyler Robinson's defense should actually be requesting the body cam footage, because you want to know what happens on a body cam is as it's recording, it tells you the time, the date, and you want to know what it also says? It'll tell you your battery level. So when your camera is getting ready to die and you're screen recording the camera, what are you getting? You're getting a fucking blinking light. You're getting a red light. You're getting a warning sign letting you know you're at 10%, 15%, 20%. I mean, just think about your iPhone, right? Displays it right there. And if you're screen recording your iPhone, which your body camera is recording all of that data and all of that detail so it can be then presented in court. If your battery is dying, well, then we would see your battery die, wouldn't we? And we would be able to see your hands. We would make sure that your hands are out here, right? They're not pressing a button, right? But when you watch your hand come over in the same direction that your power button is, well, we could assume that your battery didn't die, that you specifically turned off that body cam footage. And there was supposed to be another officer on the roof, right? So who is the other officer? Do we have his body cam footage? Because it'd be very interesting to see all of these cops all on the roof, all at the same time simultaneously, and yet nobody mentions where they found the screwdriver, when they found the screwdriver, who found the screwdriver. Did anybody find the screwdriver? Was it on the roof? Was it next to the rifle? We don't fucking know. This is such a clusterfuck shit show. I don't even know if you can make heads or tails of it. Yep. Definitely aren't going to have enough evidence for a jury to convict.
Yeah, so as someone who has used a number of body camera footage, or someone who's used a number of body cameras myself, I can absolutely tell you that all of that information will be on there, right? And I can't remember if there will be a noise, but you will definitely be able to tell when it dies. Obviously, because you'll look down and it's not recording, right? But as well, you could tell the battery, the charge on it, right? A lot of the times, what I've used was like there was a battery with like 3 bars, and I don't want to say that's pretty common, but I do want to say that the cameras that I use specifically had that design, so or that function. But they will absolutely have they will record, or maybe not record, but there will be an indication of the battery level. So I would be very interested to see that body camera footage. It looks like we're going to have to file a FOIA, another FOIA. It's interesting how we have to file FOIAs to get actual information instead of super grainy footage from cameras that were being developed in the 1990s. So, or I guess in the 1980s, wherever, right? Because Ryan was saying earlier that 1990 security CCTV footage was a lot better. So
Tyler Robinson, that's for damn sure. Because if they wanted to convict a man, they would just show us the video of him taking the shot. Considering they have the video of him running off the same roof, and the camera angle would have showed him laying in the prone position. Where the fuck is the video of Tyler Robinson taking the shot? Anybody? And it's so zoomed out, so far away, such cropped bullshit. I don't fucking buy any of it. Fed slop bullshit 101, our government covering up the assassination of Charlie Kirk, which they played a role in. Anywho, I digress. We out, motherfucker.
All right, yeah. So, what about the video footage of the 2 men that was recording, so supposedly recording Tyler right before the shot rang out? What about that? What about that? I haven't seen anything on that at all. So, I guess we'll just have to see, right?
So this video is for all my law enforcement officer homies out there. I mean, firefighters, law enforcement officers, doctors, nurses, anybody that wears a body cam that documents information. So a body cam is a little bit different than a camera. Camera, I'm trying to capture what's in front of the lens. The body camera, I'm trying to capture what's in front of the lens while simultaneously documenting metadata, time, location. Some of these body cams will actually give you GPS coordinates specific right here at this exact inch or square foot within a meter. I'm at this exact location at this exact time. And the battery percentage of my equipment should also be documented in that metadata. The body cam I used was right here on the screen.
Something I forgot to mention was that the cameras that I used when I was private security is yeah, there were 2 things that were displayed, where absolutely the time and date, and then also the battery level, right, with the 3 bars. So that's very interesting to me. Well, actually, I don't think that oh, no, those recordings, they wouldn't. Yeah, that body camera footage would not capture the battery level. I don't think. But there should be maybe some beeping or something like that, I would imagine. I've never used law enforcement body cameras that and I've never been in that situation where there's a body camera that might have been dying, but there is something to what he said, though. I do remember someone from law enforcement telling me that to start a camera, right, they would have to go and tap the camera a couple of times to wake it up, essentially, and start recording. So I would imagine that there would be kind of the same same thing. Also, something that I just realized too, in a lot of body camera footage that I've seen, whenever footage starts rolling, you typically hear a beep, right? There's typically a beep beep, and then it'll start recording, right? So I would imagine it would do the same thing, perhaps. But yeah, so there's something to that for my law enforcement out there that are actually out doing this. Make sure you guys speak up. Let me know. Feel free to reach out for my law enforcement people out there that that are very familiar with body cameras. Do they display information while recording, such as battery level, time? I don't think that they do. I really don't think that they do. But what about the beeps? Do they beep when they turn off? Do you have to tap them twice for them to come on? Like what is it that that we could probably use as an indication of them either dying? Do they do chirping like the Motorola radios? Like what do they do, right? Because we want to get to the bottom of it. We want to understand why is it that the body camera footage cut out right as Bagley got onto that roof. That's what we want to find out.
This body cam right here documents my battery percentage. So when I'm playing that footage back, it shows you exactly what percentage my battery was at. So now when we talk about the Tyler Robinson investigation, Officer Bagsley is claiming that, as soon as he happened to get over to the roof where he found the screwdriver on top of the Low C Center, actually he didn't find the screwdriver. Cash Patel showed up a couple days later, and Cash Patel found the screwdriver and then had it tested basically within a few hours to find out that Tyler Robinson's DNA was on it. And then he went on national TV and broadcast that to the world. Well, there's a lot. He forgot to mention that Lance Twiggs' DNA is also on that screwdriver. Pretty strange that a random screwdriver, Lance Twiggs, has his DNA.
Three people's DNA. Well, no, that's probably no. I think that was I think that was the rifle. Like 3 people's DNA was on the rifle, which is interesting to me.
DNA on that exact same screwdriver, but we can digress from that and talk about that in a different conversation. I want to know if Tyler Robinson's defense is going to get that body cam footage. I want to see what the body cam footage that you were recording was seeing. I want to see the metadata of it, and I want to see that it's dying. It's at a 5% battery when you're leaving the roof that was behind Charlie, and then by the time 21 minutes later when you make it over to the Low C building, well, obviously at that point in time, you're, 5, 4, 3, 2, 1. I want to see that gosh damn battery percentage get down to 1% the second that you step foot on the Low C building. And if it didn't, well, then you're technically tampering with evidence, in my personal opinion. I mean, that's what you should be charged with as a law enforcement officer if you specifically turn off a body cam, which most local law enforcement it's required by law for you to wear a gosh damn body cam at all times. And you want to know what they most likely have on them?
Yep.
Just like a GoPro does, right? Beep, 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 beep. You know it died. You always carry a backup battery on you. And it's as simple as opening a slot, pulling out one battery, slapping in the new battery, closing the door, and going beep. And that body cam should be like a gosh damn breathalyzer for these officers. It should be mandatory that that fucker is back up and running within minutes of it dying, 5 or 10 tops. And all of that metadata should be recorded, so Tyler Robinson's defense, if it wasn't a sham trial, should have no problem getting all of that data. Let me know if you're a law enforcement.
Yeah, well, we will have to see that. But this is absolutely a bogus fucking trial. They're going to convict him off of hearsay, and then they're going to trial, and then they're going to convict him through whatever the fuck means they want to. All right, the FBI has been pushing for Tyler to be convicted for almost a year now. So it doesn't matter what evidence the defense has or what even the prosecution brings in, they're going to convict him. Because, again, they have to. The media has said this is the guy. The FBI has said this is the guy. So they're going to push forward and get and nail this guy to the wall. Okay? So, but yeah, body camera footage again anytime there's an incident, a domestic, traffic stop, high risk traffic stop, loud noise complaint, I would imagine anything such as that, anything at all where officers are making contact with the public, I would imagine that it is required by law to start filming through body cameras. Okay. So, that being the case, We all know this is sus. We all know it's sus. But let's move on. All right, so let's read this post from Nikki. Says, but wait, I thought drones weren't flying on that day. This isn't any civilian drone either. No freaking way do we have access to something that moves that fast and quietly. Well, let's take a look. Oh, let's slow that down a little bit. That could be a bird, though. I will say that could be a bird, but that is flying a little bit too quick to be a bird. Yeah, that's. What do you guys think? I think that's flying just a little bit too quick to be a bird. I think that's flying. Yeah, dude, that's moving about. That has to be about 30 or 40 feet, and just a few, just like a second, right? Oh yeah. So let's back that up. Yeah, I don't know. It's kind of hard to tell. It's kind of hard to tell exactly what that is. So, but let's take a look at this screenshot here. That zoomed in. That doesn't exactly look like wings. So, I don't think you could really say that it looks like a bird, right? It does look like something. That's interesting to me. Yeah, that's very interesting to me. All right, last thing that we're talking about before we call it. So, post by Stu says, defense, were you involved in the decision to pave over the crime scene? Oh, no. Did you know that happened? Only because it was on the news. Let's watch the video.
I want to go back, if I can, to the scene itself, the preservation of the actual scene where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
Interesting. Yeah. Nothing to see here, of course. Nothing to see here. So, exactly just as Stu talks about, how is it that an agent leading the entire investigation doesn't know that the crime scene was paved over? Guys, they took 10 inches of soil and paved it over. Why would they do that? It's a crime scene. It's just one thing after another with this entire thing, right? Yeah. Yeah. No, I'm not buying any of this Fed slop. I'm absolutely not buying any of this Fed slop, bro. It's absolute horseshit. It's absolute horseshit. So, but, well, that is day 3 and we will return. They said 9 a.m. 9 a.m. tomorrow, which is their time. So I think that is 11 our time. I think that is 11 our time. Here, let me see. So 9 a.m. Mountain Time is, yeah. Here, let me check real quick. Yeah. Yes, 11 Eastern Standard Time tomorrow is when we will be returning for day 4. So, I mean, not really anything too much to note except the long-winded back and forth of the reason for admissibility with the, I guess, text messages and the video of Lance taking of Robinson admitting to shooting, I guess, right? So, but we pretty much talked a lot about day 1 and day 2 very early on in the stream. So at the beginning of the stream, so I will be clipping those and making videos of them so that you guys can watch it in smaller segments. Because I know some of you guys, don't sit for 5.5 hours. Hell, most of you aren't even staying for 5 seconds. So, I'm gonna have to make it into some shorts as well. So, but yeah, definitely some stuff to talk about when we return tomorrow. Whenever we have a little bit more to digest, think about. But already this is looking to be botched, and I do mean botched as fuck. So, anyways, guys, you guys make sure to take care of yourselves. I'm going to start up another stream because I told you guys I would do a little bit of ARK tonight. So just give me a little bit. Let me grab a bite to eat and then a coffee, and I'll start up some ARK Survival Ascended. So appreciate you guys sticking in there. I do know I see one of you here. Unfortunately, there's just one, but for the one, and I think it's Amma, right? There is one person, and even if it's just one person, sticking here, I really appreciate you. Oh, Neo, is that you? Is that you that's hanging in here all this time? It was you, Neo? Dude, Neo, I really appreciate you, man. I really appreciate that support, dude. That was you. Wow. Well, I appreciate it, man. I appreciate you guys sticking in there, especially if this isn't your kind of content. I deem this as important, right? The Tyler Robinson case, and I've been covering it long before I've done any gaming and stuff like that. So, or at least much gaming. So, this is something that's super important to me, and it kind of goes back to my earlier content as well. But yeah, so we will definitely pick up tomorrow at 11 a.m. Eastern Standard Time. I'll be sure to start streaming a little bit early so we kind of can go over just a little bit of things that just sound a little bit weird, just to digest and talk about a little bit more before day 4 starts. I think tomorrow is going to be another long day, so I want to try and see if I can fit a mental health live stream tomorrow, but we'll just have to see how it goes. So that being said, guys, I will take a few minutes, get a thumbnail and everything ready, and then we'll start up the ARK Survival Ascended stream. Okay. So for those of you who I will not see the rest of the day, I will see you guys soon. And you guys, please take care of yourselves. I love you all, and